matters will be should appear as to be mentioned today, so that it could be tagged with the original side matter which is listed on 27th of my lord January. My lord, I don't find it appearing, my lord, today for some reason. May it appear tomorrow, my lord?
Give the list.
This is the list. She wants them to appear today.
Keep it tomorrow as to be mentioned. Tomorrow is to be mentioned.
I've given all the numbers.
Lord, may I be permitted to mention?
Your Lordship, may I be permitted to mention item number 90? Your Lordship, in this matter, the first round of writ petition has been filed by the petitioner, wherein Justice Sinha has ordered that if the OPC certificate is found false, then appropriate steps to be taken and it may be cancelled. And the SDO has already conducted an inquiry wherein they have found that the OBC certificate is false. And after that, no revocation, no cancellation under Section 9 has been taken by the SDO, and the Pradhan is still continuing the post of Pradhan on the strength of that fake OBC certificate.
Whether the order of the Honorable Justice Sinha is under appeal?
No, Lordship.
No.
After that, SDO has conducted an inquiry and passed a recent order that it is a fake certificate.
When the order was passed by the SDO?
23/7/2025.
SDO concluded inquiry.
Yes.
But it is still the
Patient.
item number 90. It is under the heading which? Adjourn motion.
In motion. Let me check.
Under which heading it is? Adjourn motion. So what you want?
Your Lordship, kindly take it on any day of this week because the
You are having adjourn motion. You are having the diary. The date diary. See when the date for the urgent motion. Not first week of February. Go to the first week. 29 January. 30. No, that yes. So I am fixing on 29 January as urgent motion. Take that.
Lord, may I be
Yes. Let the senior. He is the senior.
Yes, senior most. I have appeared with him as his junior.
Okay.
May I be permitted to mention one matter? This is the pension matter. Pension not been granted, I get on a petitioner in the senior citizen 67 years. Any day your Lordship takes up matter.
When he retired?
He was retired at the age of 60, 2017.
So till date the pension is not released.
Pension not been released. It was hearing was conducted. Opposition reply is completed. But any day your Lordship taken up, otherwise he will die.
So it is a hearing matter.
Yes,
affidavits completed.
Completed.
फरवरी में देखो 2 बजे कौन सा डेट फिक्स खाली है फरवरी में एनी डेट इन फरवरी फॉर 2 PM हियरिंग
कॉल भालो আছে हियरिंग में तो फिक्स नहीं है
हैं
2nd February
already fixed 6 February 2 PM not 2 PM already fixed I think next when the 2 PM is not fixed so 9th February 2 PM 9th February 2 PM under the heading especially fixed matter.
Yes, sir.
Yes, let the senior.
I'm sorry, on notice I mentioned one of the largest ferromanganese suppliers in West Bengal blacklisted without hearing and notice so cause by steel. Now every day contract.
Color of manganese what? Color?
There's a competition commission issue also cartelization. Your full business will come to an end this way. Now, post facto, they are starting to give show cause notices. Lord, we have filed a writ petition challenging the blacklisting. Lord, please permit it to appear as an urgent motion.
Urgent motion.
22nd, my lord, I'll have to respond to the first show cause notice. Before that, my lord, I must, if your lordships permit, my lord. I will not take much time.
21st January, see. 21st January at urgent motion. How many matters are there? 21st January urgent motion. How many matters are there? So many. 22nd. 3rd. 22nd. So many. 29 January. 29 January. 29 January. You want
I'll have to respond to the show causes by 22nd.
22nd.
Yes, my lord.
20 को देखो कितना है 20
ठीक है
year 19 19 ठीक है 19 था अर्जेंट मोशन
19.
19 and urgent.
May I be permitted to mention upon notice to the served to the other side, my lord. The respondent authority illegally acquired my land and they never paid to my land's value. That's why the Honorable High Court direction to file affidavit in opposition. Till today, I have not received the copy of the affidavit in opposition. Even I have already stated to my the other side by way of letter. No copy has been received by me till today. That's why I mentioned before your lordship under heading hearing, my lord. Any date, if lordship, any date, any month.
Under the heading hearing, but the affidavit is not completed. What can be done? First, application.
But my lord, till
If I
today,
fix the date and they will come, they will want to file the affidavit.
let it be any date. In the meantime, I shall.
I am fixing a date as to be mentioned. You inform. If the other party will not fix, then I will
Yes,
fix
yes,
the matter.
yes, yes.
So give the list. Let the matter be appear on 16th as to be mentioned.
Yes.
Inform the other side.
Yes, yes.
Bring the other side. 16th.
This is the two matter for restoration.
As to be mentioned.
Lordship 16th
Lordship,
Yes.
Lordship, this is the matter.
Let the senior. Yes.
Milord, a matter has been released by the Honorable to court number 24. Where the father died.
What is the matter?
Milord, it is a home loan and the borrower died, Milord, and on the next month it is closed. But the bank refused to give the title deed to the
total loan amount paid.
Total amount.
Okay.
Milord, it is.
So what is the urgency?
Milord,
The
it
matter
is
will
the
come.
motion. They are now denying everything, Milord.
10th February urgent motion में रखेंगे. 10th February.
May I have my lord's kind leave to mention,
This is
Lord.
the two matter for restoration due to illness of the advocate of on record.
Restoration.
Restoration matter.
May I have my lord.
Thank
21st January
Grateful.
under the heading application.
Grateful, my lord.
21st January.
May I have my lord's kind leave, Lord,
Lord,
to
I have
mention, my
mentioned
lord.
you an urgent application for vacating interim order before to appearing in the list in view of the fact that due to interim order passed by this honorable court, the completion of Amrit Bharat project of a railway station, Barasat railway station, the junction is stalled because the stallholder obtained an interim order, although his term has expired on June 20, 2025.
When the interim order was passed?
That not to recover the possession from the stallholder.
When the interim order was passed?
That is the May, that is about 2 years back.
2 years back.
2 years back.
So you were not mentioned matter. Now you are mentioning after 2 years. Whether affidavit is completed?
Yes, well, application vacating I have.
No, application vacating it's
Yes,
also.
yes.
What about the main application? 2 years affidavit is completed or not?
Affidavits are complete.
Affidavit is completed. You sure?
Yes.
So I will fix the matter as a special fixed matter. All application along with the writ application will taken for hearing.
My lord, my lord.
See February कोई कौन सा डेट है 2 बजे खाली देखिए.
Lordship, I am mentioned.
February देखिए second week में 2 बजे at 2 PM. Huh? 2 PM is vacant. 9th February at 2 PM as a specially fixed matter. Inform the other side. Otherwise, if they will say that you are not informed, then I will not take up
No,
the
no,
matter
my
for
lord,
hearing.
actually-
Yes.
Lordship, I am mentioning item number 63 of the daily list today. Sum of about 1.28 crores is due to the petitioner. He is unable to make payment of his GST dues. He is facing multiplicity of proceedings. I am praying that this matter be taken up as an urgent motion.
Urgent motion.
Any day which suits your
5th
lordship.
February देखिए urgent motion में कितना matter है? Urgent motion. 5th February, 6th February. 6th February? 6th February as urgent motion.
May I mention item number 395 of today's list, my lord. My lord, the petitioner wanted to foreclose his loan earlier, the prior period, to the, he sends favorable representation to the bank, but it has not been.
What is the condition if you want to close the total interest is to be paid, or from that only the interest is to be taken into consideration? That is the only question might be.
My lord, that is the only question. Now, what happened, my lord? During the representation, along with this, when the representation for the petitioner father, who is a cancer patient, along with he is suffering liver disease also, he is in presently hospital. I have been informed to that let the matter be considered before, because I have also made representative, the petitioner also made representative.
But the bank says.
Bank says nothing. Orally, they are saying that you have to pay the entire amount, but on table or any kind of representation has not been.
6th February or 9th February?
And I have served, my lord.
6th February?
6th February.
May I have your lord-
As urgent motion.
Urgent.
May I have your lord-
6th February. 390.
Matter for correction of an Aadhaar card.
Obliged,
Date
my
of
lord.
birth error. Thereafter, a correction application was made. Yes, pending since 2024. Insurance company, Lordship is aware that the provident fund dues and all the amounts that have to be paid now are all linked to the Aadhaar. Lord, the date of birth mismatch in the two documents, Lord, that pension, that the benefits that the petitioner would otherwise be getting from the insurance, that is not being paid. Documents,
9th February.
May I have your lordship if
February
to
urgent motion.
With your lordship's kind leave, my lord, may I just have your lordship's leave, my lord, matters regarding the LOCs, my lord, that was made few days back, and your lordship had fixed it on 15th of this month, my lord, for you. My lord, those matters, my lord, we were just praying for an oral leave to perform to supplement the affidavits and serve copies upon the.
May I have your lordship leave to mention? May I have your lordship leave to mention a matter for inclusion, lordship? This is a matter filed for filed against RTI application, lordship. RTI has been
Not in the list.
no, lordship. It is not.
New motion?
Yes, lordship.
New motion.
Also with regards to the encroachment of the property of the Waqf estate. Now I have to register as per the news portal, and Supreme Court has declined extension of time. Unless Mutawalli is appointed, I cannot.
Since when the Mutawalli is not there? Since when the Mutawalli is not there?
Mutawalli is not there since 2009. We made an application back then. It was published.
Whether you are eligible for the Mutawalli post. Correct.
I am the only surviving heir of the family. Now that has to be decided. I made a representation. I made several.
Who is for the other side? So what is the urgency?
After this, Honorable Supreme Court refused to extend time for registration of my property in the. Now they might levy some late fines, which liberty has been granted by the Honorable. Unless I am Mutawalli, I cannot register my. That's the only.
10th February urgent motion.
Your lordship.
10th February urgent motion. Urgent.
Your lordship, I'm late by Mr. Banerjee. Auditor Banerjee is.
Yeah. Item number 541 of your lordship's list, my lord.
Yes.
Extremely urgent matter, my lord, because the state government wants me to pay full stamp duty on the purchase of, my lord, a right of reversion of a 99-year-old lease. Now they say that their computer will not permit me to put in my registered conveyance without paying full duty as if it was a estate in fee simple. I am completely undone. There's already a lease. I am purchasing with the lease. So I am purchasing only the right of reversion. Valuation of the right of reversion is 57 lakhs. I have had it valued. But they insist that I must pay entire stamp duty on the money taken on the property, taking it to be an estate in fee simple. That is a few crores. I mean, I will be undone. I am not purchasing the entirety of the right. I am purchasing only the right of reversion. I am permitted in law to do that. Registrar says that the computer does not permit him to do it.
So who has assessed the part of the property? Who will assess?
Though I have assessed myself with the help of a valuer. They refuse to assess. They say if you want to purchase anything, any right, you have to pay amount equivalent to the full consideration under Schedule 23, item number 23 of Schedule 1A of the West Bengal Court Fees Act. This is mayhem. If today, my lord, I purchase a right in a property, I'll
So
have to pay for them.
what is the urgency, Mr. Banerjee?
My lord, my transaction isn't happening. There is no agreement for sale staring at me. If this transaction doesn't happen, my party will go. They are not going to
Who
do
is for
any
the other?
agreement for sale.
Who is for the other side?
My lord, I have given them notice.
How many
my lord.
matters?
No, one matter, but there are 9 parties, your lordship.
There are 9 parties, but then most of them are registering authorities, and my lord, the persons who are my prospective vendors are running away. They are saying if you don't have it registered, that's the end of the road.
Only in February, as urgent motion. Only in February. This week, this month, I don't think so. You will get any
My lord,
date.
I was just, my lord, hoping against hope. Today being a Monday, hoping against hope, my lord. If possible.
Correct. My diary is totally full with regard to urgent motion matters. If I fix also, I don't think it will be taken up for it, because today I am having the 70 matters in the urgent motion, 50 matters in the urgent.
My lord, I will not put the court in such a predicament, my lord. Let it then come up, my lord, any day in February, but fairly at the top, my lord, so that I can.
February, 6 February urgent motion I will take.
Yes, I am obliged.
My lord, on my mentioning your lordship has been pleased to fix a matter on 2nd, my lord. My lord, this matter.
2nd of January.
January. My lord, first up I was there, but due to my father's sudden illness, my lord, I gave to the court, my lord. My lord, the urgency is this, my lord. My lord, the petitioner before your lordship is the student who is the aspirant candidates for, my lord, NEET 2026, my lord. My lord, there is a mistake in Aadhaar card, my lord.
NEET?
My lord, UG NEET, my lord, National Testing Agency, my lord. My lord, I applied through my lord online portal for correction of Aadhaar card, my lord. 5th of January, my lord, NTA, National Testing Agency, published a notification that for rectification of Aadhaar, date of birth, and all these things has to be made immediately. Otherwise, the candidate.
What is the cut-off date for
this notification has been published on 5th. I have annexed with my notice, my lord.
So
normally, my lord, 2 weeks. They give me 2 weeks time to, my lord, correct all these entries, my lord.
Correct.
My lord, I have made my application before the, my lord, Aadhaar authority, my lord, through online mode in the month of August, my lord. Till date, my lord, they have not, my lord, corrected my record, my Aadhaar card, my lord. Well, any day, as per your lordship's convenient, my lord.
20th January.
Your lordship, I have.
Urgent motion.
Your lordship.
Urgent motion.
Lordship mentioning for
Hearing.
We have mentioned it last, but it was not in the list.
Okay, put in the hearing list.
Your lordship mentioning for inclusion. Lordship.
For what? Inclusion, give the list.
My lord.
Lordship, this is the matter in respect to the banks, wherein Mr. Jishnu Chaudhary was addressing a lordship and got an order from your lordship in case of one of the banks. The 2 of the matters have already been fixed tomorrow as urgent motion. Lordship was mentioned before also on the time of hearing. There are other 2 matters, same nature, which should also be on the motion for all to be disposed of altogether. There are 2 matters. I've given them notice. I've put the orders also annexed here with of your lordship's order. Tomorrow the matter is fixed for urgent motion, your lordship. The same matters, the same type matter.
Tomorrow's number is there.
Today's number. Tomorrow
which matter will appear, but the number is
yes,
there.
Your order sheets are there, your lordship. The item number is not.
Does it? Not that number is there.
The number is there, your lordship. 2 matters, and this 2 matters I'm mentioning today.
These 2 applications will also be listed along with the other 2 matters. Tomorrow is urgent motion. If it is tomorrow.
May I be permitted to mention one matter, my lord? My lord, the petitioner is a retail business owner, my lord. The petitioner is a retail business owner, my lord, and one of his customers has paid through IMFS transfer, and then the petitioner's account got frozen, my lord. And after that, my lord, the petitioner could not do any transaction in his business account.
Is there any criminal case initiated?
Yes, my lord, the one Maharashtra criminal case has been initiated, but my lord, he is not linked with the any cyber crime complaint since the trail of accounts has been freeze, and my lord, the already it is a settled position of law, my lord, that the indeterminate inordinate means in for a long and continuous period of time the accounts cannot be frozen, my lord, like this. The petitioner is suffering, his business account has been frozen, and also his PAN card has been deactivated.
9th February.
May I be permitted to mention a matter?
9th February urgent motion.
My lord, may I be permitted to mention the Rohingya matter? My lord had fixed it on 9th. My lord, I mentioned on 9th because it did not appear in the list. My lord, today also it did not come up in the list. If my lord, if my lord fixes it any time today, my lord, I will inform the union and the state. My lord.
कल 12 बजे फिक्स है। Nothing. That may be taken as tomorrow as a specially fixed matter. Inform tomorrow 12 noon and a specially fixed matter.
Great.
I mentioned I took 500. Whether my client is prosecuting. They have not considered under my own name of all where an process my own extracted something it is already been given. I know that. I want to know
What is the urgency? Let it February. January, I don't think any 29 January देखिए कोई matter कितना है because my diary is totally urgent, otherwise it will again matters are there. 29 January करेगी urgent motion.
Lordship, may I be permitted? Lordship, may I be permitted? Lordship, this matter was previously filed before the Honorable Justice Amrita Sinha, but after the change of the determination, it has come before Lordship, and this is the 5th time I am mentioning this matter for inclusion.
What is inclusion? Give the inclusion.
The matter is not been listing.
Give, it will be listed.
May I be permitted?
Inclusion, give all the list to my court officer. Only inclusion. Give inclusion.
Your Lordship
give.
may kindly permit me to mention.
New motion.
May I be?
List. Only include in the list as a new motion.
Your Lordship may kindly permit.
When interim order is going to expire? 15th of January. 15th of January. Okay.
Your Lordship.
Usko, let it be fixed on 14th January under the heading to be mentioned for extension of time. Extension of interim order.
Your Lordship may kindly.
Court will give the money. So what the court will do? What is your prayer? To terminate the policy, or you want to? What is the amount involved in the policy? So you want to take back the policy. You don't want to go to, till the date of the maturity. So what you entitle, you are ready to take back the amount because the insurance will not give the maturity amount to you. If you want to take back the insurance policy, you will not get whatever the amount you have deposited. You inform your client because you will not get the whatever the. I don't know.
Your Lordship may kindly permit.
10th February.
Your Lordship.
10th February, urgent motion.
May I be permitted to mention one hearing matter? This is in the compassionate apartment, ad hoc pension, payment in lieu of compassionate apartment. Let it be listed, this was 3 times.
When the government servant died?
Died long ago. The application was made in.
When the government servant expired, sir?
Expired in 2008.
When you apply for the compassionate appointment?
That is the appointment I have made in 2009. But they have refused my compassionate appointment. The Indian bank agreed to give in lieu of the
compensation
amount according to their scheme.
Correct.
That matter was direction for affidavit was for. They have not given affidavit. It was previously listed before Honorable Justice Chatterjee.
So what you want?
I want inclusion in.
If the affidavit is not there, what will be done?
They will not give any affidavit. They have 3 times.
Okay, I am fixing as a to be mentioned. You inform the other side. If they will not come, fix 29th को to be mentioned में रखिए.
Ye Lord, may I kindly.
Other side. Yes, Mr.
Because these are ready for hearing matters. You have mentioned this, but unfortunately, as a motion. The urgency is that the election, this concerns which the West Bengal Medical Council
Affidavit filed. So it has hearing is to be fixed. 2202. देखो 2 बजे कब फिक्स खाली है फरवरी में?
Your Lordship may kindly.
फरवरी में कब खाली है देखिए. Hearing especially fixed. Hearing as especially fixed matter. फरवरी में देखिए कोई डेट है? Okay.
Your Lordship.
In respect of a matter, Lordship, the private respondents are standing in the way of effective electricity. Private respondents are standing in the way of effective electricity connection. Lord,
The electricity is not determination. This court is not having the determination of electricity, sir.
Your Lordship, may I be permitted to mention a matter, Lordship? This matter has been substantially heard. I have been declared fraud. I'm being led by Mr. Bhattacharya, who is online, Lordship. And admittedly, in the affidavit, the forensic audit report has not been served on me.
Last occasion, Mr.
Yes, on the last occasion.
Yes, my lord. Yes, my lord. I'm leading Miss Mitro, my lord. Here, my lord, Mr. Tiwari was appearing for the bank.
Correct.
On the last occasion, he said that he's going to he was going to look for some judgments and apprise your lordship if they find some judgment in his favor. Now it is appearing as item number 47, my lord. I have been declared a fraud, and Mr. Tiwari has said in court that my name has gone to CBI.
47, it's urgent motion. Please today how much it will reach tomorrow
Yes,
it will
yes.
come up. No
Very
problem.
well, my lord. Very well. Grateful.
I had mentioned 4 matters, my lord. Matters related to a tiger attack.
Huh?
Tiger attack, my lord.
Tiger attack.
The husband of the petitioner died.
So what all four?
All four, my lord.
All four are the injured of the tiger attack.
Injured but died.
Died. All 4 persons.
All 4 persons. Compensation has not been given.
When they died? When this incident was occurred?
25.
So what do you want?
But to hear out the matter, my lord, the poor wife is facing.
So that is the affidavit this is to be decided only after the affidavit, sir. Compensation how it can.
My lord, hearing to be done, my lord. Your lordship was pleased to direct the matter will appear 29th June, 29th January, my lord. But 3 matters are appearing as new motion. 1 matter is not appearing.
29 January.
Yes.
January not yet come 29
But,
January.
New motion. 3 matters are appearing as new motion, my lord.
Okay, 1 matter is coming on 29 January.
But that I do not know, my lord.
So you are telling that the 29 January date is given.
Fix the matter, but 1 matter is not appearing.
29 January any date is given.
29 January.
So let come on that day. If it is then all the matter will be taken together.
The matter, all the matters, my lord. If your lordship directs, my lord, all the matters be heard out. But I'm giving.
Take and fix the matter on 11th of February at urgent motion.
Your Lordship may kindly permit.
11th February urgent motion.
Your Lord.
Yes, auction purchase, but I have purchased the vehicle. Now, my lord, the original owner from whom, my lord, the bank has taken out this vehicle, my lord, he has filed an injunction for which, my lord, I have purchased the vehicle but couldn't make the registration because of an interim order, which has been.
So go to the interim of the civil suit. How the court will enter this?
That issue is, my lord, they are suppressing everything, my lord. They have sold this vehicle to me, my lord. That's what I am seeking. Only lordship can take up this matter any day, my lord. Fix, my lord.
No, if the matter is before the civil court pass an interim order.
The party, my lord.
You are not the party.
No, my lord. I am not the party. By suppressing this fact, my lord, the bank has sold the car. I have purchased the entire consideration money. I have paid the purchase this vehicle.
10th February. 10th February.
Your Lordship.
Permitted to mention a matter.
No, further come tomorrow. Further.
Your Lordship. Your Lordship.
Come tomorrow.
Well, only thing is, but in my matter, it will be in. My matter, it will be infractions unless the leave is granted.
Whenever I have given for the mentioning matter, I have taken a fearing matter. Urgent, come tomorrow, whatever it is. I will take tomorrow.
Well, yes, I have also served the mentioning.
But I need leave.
Restoration give to my court office.
But I need leave. Lordships.
Come tomorrow. Yes, call the list. Tomorrow.
Account defreeze matter, my lord.
Tomorrow. Yes.
Your Lordship.
Come tomorrow. You don't understand English. Half an hour given to the mentioning matter. Whatever the taken, I have taken. That's all. Call the matter. Otherwise, I will take only once in a week for the mentioning matter. If you person will like do this,
My lord, I appear for the respondent, my lord, SFDCL.
My lord, I am appearing on behalf of the petitioner, leading by Mr. Somo Mohan.
What is the application?
My lord, application, because in the interregnum, my lord, we have given a termination notice. They have brought this on record, my lord, by way of this application, by challenging the same. My lord, this matter was taken up on the last occasion when your lordship, my lord, has passed a direction to give them a breakup, because the learned senior counsel, my lord, has submitted to give a breakup of the dues, because admittedly there are dues, your lordship. So that is why, my lord, they needed a breakup. I'm carrying the breakup. They can consider and come back, your lordship.
When?
It's up to them, my lord.
Yes, breakup
Last
is, you
occasion-
received the breakup.
No, my lord. Last occasion, my lord
Supply,
directed them
supply.
that they will take a instruction.
Yes, my lord, the breakup. My lord, of the entire amount, although, my lord, in the writ petition in page number 72, my lord, the details has been given that what is the amount. My lord, I'm led by my lord.
So we got to take instructions because they wanted to find out how much was actually pending. That list is already there.
So
No,
you
they've
have
not-
handed over, you received that?
No, my lord. Just now take the hand.
Have to take.
Yes, my lord.
When we will back?
Next week, my lord.
Next week?
Yes, my lord. In the meantime, no coercive steps.
No, my lord, I'm opposing anything.
What coercive steps?
My lord, they had already notice, give me a notice to hand over the possession, my lord.
Yes,
What
first the termination, they come up because of non-payment. Then they don't get an injunction. That particular
My lord,
order records, I'm going to go ahead and take steps.
Surface?
No,
No,
my
my
lord, there's
lord.
an agreement entered into with me. Under that, he's liable to pay a certain amount
lord,
of money.
My lord,
If for years together there is a default.
my lord, in can application page 26, they already take a instruction, take a notice. For this reason, I file a can application.
What is the prayer in the can application?
My lord, in can application, the notice was stay. The notice was dated 10th December. 10th
What
December.
is the prayer in the can application?
Yes, my lord. To stay the operation of the notice dated 10th December 2025, issued by the opposite party till disposal of the read application.
For what is the notice? 10 December, what is the notice?
My lord, kindly.
Got it? What is the notice of 10 December?
The notice is issued without prejudice, right and page 19 of the can application, my lord.
Page 19?
Yes, my lord.
State Fisheries Development Corporation.
But may I just indicate one thing?
Yes.
My lord, in
There's
the
an
meantime,
initial order in the writ petition which they assail.
yes, my lord.
That
They
order
filed-
records that the agreement is terminated, and I am going to initiate proceedings under section 3 and 4 of West Bengal Public Land Eviction of Unauthorized Occupants Act. Challenging that, they file a writ petition, they don't get a stay. Now the second notice is in aid of the first.
My lord, in
Now
the
again
petition,
they've come back for a second bite at
my
the
lord,
cherry.
in the writ petition, they made an opposition.
What is the prayer in your writ application?
Yes, my lord.
In the writ petition,
8 July 2025.
Yes, my
Where
lord,
is the 8
page
July
31, page
2025
31 of
order?
the writ petition.
Where is the 8 July 2025 order?
at page 103 of the writ petition.
103.
Yes.
Yes, my. I challenging the same.
Under
That
which,
if you lo-
under which section?
At 106, if your lordship sees,
My lord, last portion of the notice.
2C. 106, 2, clause C. I've stated I'm going to.
My lord, in this termination, my
They
lord,
try to get a stay, that stay is refused, affidavit directions are given. Now when I've issued a notice, they've again come forward.
Initiate the eviction proceeding under 3 of so and so and so. So,
clearly, I challenge the
so you
notice.
challenge this order.
Yes, my lord.
Correct.
Then after passing the order, they already instructed the opposition, but they not give the opposition.
Correct.
In the meantime, they already
Issued the notice.
issues the notice on
Correct.
10th July in can application 19, my lord, page 19.
Correct. You are not obtain the stay from this court, so
Yes, my
they
lord.
will continue. Without the stay, how the court, they can?
But they have not filed the evidence opposition till that, my lord.
Okay. So I am
Last
fixing.
occasion, last protection.
Okay, they
my
will
lord,
not. They will not file. I am fixing the your writ
yes, my lord,
application
kindly
for
fixing the that. Kindly fixing the.
They will not file. I will not take
Yes,
the
my lord,
affidavit in
fixing
opposition.
My lord, I'll file my affidavit in 2 days.
But
this,
kindly see the order 18
yes,
September.
that is there. Without
So
the,
then I am staying your notice.
No,
you are not to use the affidavit. 14 November is the date for filing affidavit.
Page 18,
Well,
my lord.
there is a failure to file the affidavit. But the first injunction, if your lordship sees that order which they assail, they don't get that injunction because there is no stay I've given. The fact that I've not given an affidavit doesn't change the fact that the injunction was refused. There is a gross admitted non-payment of dues. This party is sitting there.
Where is the earlier order?
Yes, that your lordship
My
will
lord,
find from the
page
present
18.
application.
Page 18 of the CAN application, my lord. Page 18 of the CAN application, my lord.
The order.
Paragraph 3, my lord.
And
Can
this
you
was-
read out, my lord?
Yes.
Let affidavit in opposition be prepared by and circulated by 14th November.
Correct.
And reply if they are any way.
Just above that, my lord,
That
the
is
order
the
is a
so
reasoned
affidavit
order,
opposition, they know.
correctness of, my lord, my failure to give him an opposition.
My lord, I
doesn't
submit.
give him a right to seek an injunction which was refused on the first day.
My lord,
He can
I
have a
have
right
paid-
to have the writ petition heard. It can't give him an order which he did not get on the first day. He is not filing a vacating. He's seeking an injunction which was refused.
My lord, last
And I tell you, lordship, my lord, this is the third round. 2 rounds have happened before where directions were given to pay money.
What is the question of maintainability?
My lord, the maintainability that we had raised was this was a simpliciter lease deed agreement that was there, and there is no public law element involved, and it amounts to payment of rentals and electricity charges that the writ court under 226 possibly can't get. There's a division bench judgment of this honorable court that we were trying to rely on and taking the point of maintainability. Because this is simpliciter arising out of an agreement, and there was a full-fledged reasoned order that we had passed. And if your lordship gives me 2 days, my affidavit is otherwise ready. There was a change in management which we had.
The petitioner has filed an application being CAN 1 of 2025, praying for history of the operation of the notice dated 10th of December 2025. Counsel for the petitioner submit that by an order dated 8th of September 2025, this court has directed
18th September.
18 September, not 8. 18 September, this court has directed the respondents to file affidavit in opposition by 14 November 2025 and reply by 28th of November 2025. But instead of filing the reply, the authorities have issued the notice for, what is the notice?
My lord, page 19, my lord. Page 19 of the CAN application.
Page 19 of the CAN.
What is for the notice? What you ask for?
Look, in the notice, we've terminated.
Notice is terminated, my lord.
Because of
Within 7 days.
non-payment.
Already I have
That
paid the
is
50%.
By terminating the
it may not be the
Just a
subject
minute.
matter of the writ also.
Notice dated 10th of December 2025, but terminating the agreement between the parties.
Separate cause of action completely.
Police. He submit that in one hand the respondents are not filing the affidavit in opposition, and second hand the respondents taking coercive action against the petitioner. Learned counsel appearing for the respondent submits that when initially the petitioner has moved the writ application, this court has recorded that the impugn order is a reasoned order, and this court has not passed an interim order, and this court has also kept the maintainability open. Maintainability of the writ petition is open. And now the petitioner has challenged the 10th of December 2025, which is not the subject matter of the writ application, and thus no interim order can be passed at this stage. Learned counsel for the petitioner respondent prays for extension of time to file affidavit in opposition within 2 days. Let affidavit in opposition be filed by 16th of January 2026 after serving the copy to the learned counsel for the petitioner. Reply, if any, there to be filed by 22nd of January 2026. List the matter under the heading hearing on 4th of February 2026.
My lord, in the meantime, they had status quo maintain volume.
Call the matter.
Time for the petition. But I have been instructed to withdraw the matter, my lord. My lord,
Where is our instruction?
Yes, lordship. But I have mentioned for the 3 writ petitions, my lord. These are mentioned, my lord. My lord has ordered that the 3 writ petitions would be coming on the list of to be mentioned, but only one has come, my lord. If it is possible. To, my lord, allow me to withdraw.
The matter is listed as to be mentioned under the heading application. Counsel for the petition handed over a communication dated 8th of January 2026, wherein the petitioner has informed the petitioner that the petitioner does not intend to proceed with the matter and to withdraw the writ application. At the learned counsel for the petitioner perused the communication dated 8 January 2025, WPA 25708 of 2025 is dismissed as withdrawn. Communication be kept with the record. Interim order, if any, stand vacated.
Let it be kept on record, my lord.
Kept in record.
Oblige, lordship.
Next.
The other two matters, my lord.
अदर दो मैटर है ना, ये दो मैटर इसको कल जो है टू बी मेंशन में कर दीजिए. एक्चुअल में तीनों आना था, नहीं किया किया है, कल वो दोनों को कर दे. नेक्स्ट. आइटम 6 15. Okay, not call. Seven, 8, 9, 9. Okay, call. I will say not today. File is not here.
So speaks on 15. That
15th. It will taken on 15th.
Very good.
7. File is not here. Not today. Not today. It will come tomorrow. Not today. Come tomorrow.
9, 7 and 9 attack.
Not today. Not today. Not today. Tomorrow.
Then, Lordship, I appear for the petitioner. Lordship, this is the IVF matter, Lordship.
Tomorrow file is not there. Tomorrow I will take this.
Item number 8 might be taken up, my lord. I was just outside.
No, file is not there.
I'm so sorry.
Because of there is some file has not come.
Oh,
Yes, next. Not today.
11, I'm appearing.
Not today. Come tomorrow. Yes, call the matter 12. Yes, Mr. Das.
Yes, also kindly
Item number
ask
12.
permission. While entrepreneur submitted that they will take instruction.
Who is for the railway?
Well, the 3 crores 67 lakhs, they are deducted from the final bill. Finally come to pay.
Who is for the respondent?
Last occasion he has appeared Manager directly because he
Joseph
has
Singh.
submitted that he will take instruction in respect of that. But without giving any opportunity, the 3 crores 67 lakhs has been deducted. Although we have given the service to the railways, Manager.
3 crores 67 lakh 96.
Yes, Manager. And we also pay for a representation before the authority. That
Who are you? How they have deducted? Who are you? But other party is not here, Mr. Das. What can be done? Not today.
Manager, on 15, Manager has fixed my 3 matters on 15. Let it be on 15.
I don't know 15. How many matters will be taken? Record. No. None appears on behalf of the respondents. For the interest of justice, the case is adjourned. Let the matter appear on 15th of January under the same heading. Next.
The respondent to this matter.
Yes, who is for the petitioner?
The last matter, the respondent matter, that the oil marketing companies matter was supposed to file the report matter on the basis. This is the cylinder blast case.
He wanted to take instruction as per your document, your supply document.
It's the answering respondent matter was the oil marketing company.
None appears on behalf of the petitioner. So and so, so and so. You are for the Union of India. So and so appearing for the Union of India. For the interest of justice, case is adjourned. Let the matter appear on 11th February under the same heading.
Good.
Next. No file. Okay. Call the 22 IP person. Not today. 15 not today. 15 not today. File is not here.
My lord, 13 I am appearing, my lord.
Not today. File is not. 13.
13 serial number 13 I am appearing.
Already adjourned. Yes. 16.
Not my I'm appearing for the respondent, Your Lordship.
Not today. File is not here.
Your Lordship, on last occasion, you are instructed to bring the GUQD report which we have brought here, Your Lordship.
Well, in fact, Your Lordship was pleased to hear it. This is that LIC matter, my lord. Agent, I am more like a corporate agent. My agency was terminated, and thereafter 3 orders of the writ court from time to time. At all times, my lord, the orders passed by the disciplinary committee and the appellate committee were set aside. And finally, my lord, there was one order was of Justice Dipankar Datta. Thereafter, there was second order was yes, correct. But I wanted to, my lord, examine 4 doctors who had given the. So if the file is not here,
not today. Not today.
Not today. Very tomorrow.
Wait for Your Lordship.
Not today.
Well, I am put the petition.
18 file is there? No, not today. Come tomorrow.
Huh? You?
Not today. Not today. File is not there.
19 I am for the petitioner. File not.
File is not.
For the state here.
20, I'm for the private respondent.
Not today. Not today. Come tomorrow.
Is it day after tomorrow, my lord?
Day after 20?
Yes, my lord.
20 records. As per the prayer made by the counsel for the petitioner, let the matter appear on 15th of January 2020. Next. Next.
21.
My lord, in item number 21, I am for the respondents, my lord.
21.
21.
Who is for the petitioner?
File not here, my lord.
No,
It is
file here. 21 file is here.
my lord.
21 onwards file is there.
My lord, there is one CAN application moved by us, my lord.
For what?
My lord, there was a arbitration clause, my lord. They have not shown your lordship, and my lord, they have attained an interim order, my lord.
But nobody is there. 21. Not today.
They are coming, my lord.
Who is coming?
Yes, being informed. Sir, my lord, kindly make it a short passover.
Passover.
I'm grateful.
Passover. 21 Passover. Next. 22. Not today.
23.
My lord, 23 to 39, my lord, identical matter, my lord, wetland matter. My lord, Mr. Omuleshwar is appealing, my lord, paying for short Passover, my lord.
Short Passover. What the court will do? No.
My lord, your lordship kindly consider, my lord, Mr. Rice engaged.
Passover.
I'm grateful.
40. Which one?
17. I reached when it was running.
Item number?
17.
17 not today. File is not here.
I'm sorry. I'm sorry.
File is not there.
I'm sorry.
That's why you put the not today.
I'm sorry.
Next. 40. No file. Away.
18? Not today. হবে না তো? হ্যাঁ, আগের দিন তো
No file. Which file is there? Okay. I will sit at 11:45. Okay, will 11:40. Number 21.
January. And my lord,
Yes.
there is, an application. I filed an application, my lord. My client has filed an application for modification of the interim order.
Modification of
the interim order, my lord.
what is the interim order?
My lord. That is can 1.
What is the interim order?
My lord, interim.
My lord will kindly take up the application of my learned friend. The order is
Respondent is absent from giving any effect or further effect to the clause 1.6 II
My lord.
of the technical bit from January 20.
My
Yes. So what is the modification you prayed for?
My lord,
Have you the can application is there, sir?
my lord, this is the application, my lord. This can application is.
No, this is the WPA.
Application ta ische?
Not yet come. Huh? Not in the file. Not in the file.
And my lord, another prayer I have made in this application that this is a contractual matter. There are disputed questions of fact involved. Now, my lord, and there is an arbitration clause, and this order was terminated sometime in 6th or 7th June, I believe. 6th or 7th June. Now, the writ petition has been moved thereafter without invoking arbitration. Now, my lord, so far the direction for filing affidavit is concerned, my lord, it is my humble prayer that first the maintainability of this writ petition in view of the disputed question of fact is involved and presence of an alternative arbitration clause.
Maintainability point can be kept open. Now, nowadays,
So it is 21st of January. It is fixed.
My lord.
in the meantime, we'll
Today we are on 7th.
We are 12th,
Today
13th.
13th.
13th, my lord.
13th. So now you immediately file the affidavit, whatever it is, or your can will be taken as affidavit in opposition.
Yes, yes.
I will hear the writ
We'll file a reply to that, and if it will, matter can be disposed.
Mentality will be taken as a
My
matter.
lord, but there is a difficulty, my lord. This matter has to be, because the allegation is termination.
Correct. Now the writ is filed, one order is passed rightly or wrongly. Now you filed an application of modification and you are raising the question of maintainability. You are raising the question of maintainability. Maintainability also is to be taken into consideration after hearing the parties.
My lord.
So maintainability along with the total matter will be taken up for hearing. If you want to file, how soon you will file, or your can application will be taken as a
No, my lord,
affidavit.
then I will file an affidavit. My lord, kindly gives me one moment. My lord, 2 weeks, my lord, will be required, my lord.
Then again it will go. You are taking the maintainability.
1 week.
If you say that you will not file the affidavit and only will argue the matter on 20, let's come on 21st, I will take the matter on maintainability of the fine.
Without my lord, that instruction, my lord, I cannot submit. So, my lord, 1 week, today is 13th.
So you do one thing, come on, you file the can is also not here. Let you serve the can, you file affidavit.
Yes,
You
sir.
soon
I'll file.
And you serve the reply, give the reply. And I am taking on 21st itself with regard to the modification.
I will try my best to
And
expedite.
if I find that the writ petition can be disposed of, that can be disposed.
My lord.
Within a 10 days.
When you file, have you served the copy?
Yes. It has been
Today
served.
we are on 12th, 13th. So by 16th you can file.
My lord,
From Delhi, Your Lordship. At least
at the daily, we get it notarized.
7 days, Your Lordship, kindly.
Huh?
7 days time. 7 dine korad bochhe.
7 days, 13, then it will come to 20. Then they will
21st is, then Your Lordship, the reply will not come.
You give the advance copy on 17.
Yes.
And you file the affidavit in reply by 20. So 21
Advance copy. We'll give the advance copy, Your Lordship.
Give the advance on 17.
Yes.
And you file the affidavit in reply by 21st. I will take the.
And I'll file the affirmed copy, Your Lordship.
In the form. The respondents are agreed with the interim order passed by this. The respondents have filed an application being can number
My lord, 1.
Can 1 of 2025, praying for modification of the interim order. The learned counsel for the petition and respondent also raised the point of maintainability of the present writ application on the ground that the matter is connected in the agreement there is a arbitration clause, but the petitioner instead of invoking the arbitration clause has filed the present writ application. This court find that the matter is, this court has already extended the interim order on 21st of January 2025. Accordingly, the petitioner is at liberty to file affidavit in opposition of can number 1 of 2025 by 17th January 2025 by giving the advance copy to the learned counsel for the respondent. Respondents are liberty to file affidavit in reply by 21st. List the matter on 21st of January under the same heading. Next.
By 17th, I'll serve this advance copy and then I'll file. I'm great.
File on that day.
Yes.
You give the advance copy.
I'm great.
Next. Next passover 23.
My lord, 23 to 39, my lord, I am praying for, my lord, another short Passover, my lord. Mr. Roy is.
Then not today.
My lord, your lordship kindly
Okay,
consider.
passover. Call the matter.
My lord, your lordship kindly consider, my lord, Mr. Roy is appearing, my lord. He is engaged in.
Correct. Passover. I have.
He has come today for this matter, my lord, from Jalpai.
Then I will go.
No,
Where he is available.
kindly consider, my lord.
What consideration you want?
Already. My application is there.
Heard.
My lord, I have filed one connected application in this matter that is also appearing, my lord.
Call the madam.
My lord, 2 p.m., my lord, your lordship time. Lordship.
Then 5:30.
No, my lord, my lord.
Lordship 40, I'm praying for short Passover, Lordship.
At
on
2
behalf
p.m.
of-
I have some personal difficulty. Let it.
Which matter?
There.
Not only passover, not 2
today.
2 p.m. already fixed matters are there. Only passover, the both party will come, I will take the matter.
Lordship 40 also, I'm praying for short Passover.
Not passover, not today.
Lordship 23, item number 23, Lordship, it is Passover or
40
it
not
is
today.
not today?
Next. Who is for the petitioner?
Your Lords, I appear on behalf of the respondent number 5 in item number 41.
41, who is for the petitioner?
Mr. Shumandatta.
My lord, I'm praying for an accommodation of 1 day on his behalf, my lord.
Why the government is paying us?
5 and 5. So far as 5 and 6 are concerned, I'm not seeking any relief against them. So far as this,
You are appearing for the 5.
I am appearing for respondent number 5, Your Lords.
I'm not claiming any relief against them.
You are appearing for?
Yeah, I'm led by Mr. Shopun Banerjee.
Ah.
He's appearing for state, my lord.
State. What is the matter?
My lord, it might come back to your lordship, my lord. There are 2 writ petitions are pending before your lordship regarding, my lord, non-payment of hemoglobin machines which we had supplied to the government. Now, my lord, the first writ petition was filed in which, my lord, there is an interim order subsisting. And in that interim order, my lord, the state was directed to give a report. The state gave a report showing the basis for which, my lord, they have disputed. The lordship did not be troubled with so many papers. My lord. This is a very small application. So, my lord, they came up with a report saying that the machines that we have supplied to them are defective. And that report was filed before the court. We have taken an exception to that. Now, my lord, this machine, my lord, this, my lord, like we measure, my lord, the glucose, sugar, my lord,
Hemoglobin.
So, my lord, it has a machine and there is a box of strips which comes with the machine. Now, this box of strip, my lord, has a chip. Now, if one has to measure it correctly, my lord, the chip has to be taken and inserted in the machine. It has a code, say, my lord, 61161. And the corresponding strips in the box also have the same code number. Now, if the chip and the code matches, my lord, then it is supposed to get the correct. The initial order was in May for which supply of 86,50,000 and all. We have supplied to the extent of, as of now, 66, 67 lakhs of materials have already been supplied. there is already a satisfactory certificate to that effect from the respondent concerned itself. Now, my lord, when we ask for payment, my lord, they raise this dispute that your machines are defective. All I have asked for here is this, my lord. I have given names of, my lord, kindly come to page 27.
Para 27, sir.
Para 27, I'm sorry, I said.
Yes.
So that I have given name of 4 institutes. They are all Indian Institute of Medical and various. One in Bhubaneswar, AIMS New Delhi, AIMS
Para
Bhubaneswar.
27 of repetition.
No,
No, no,
can one.
I'm moving the can.
Can नहीं है. पीछे ठीक. Yes. AIMS Delhi. These laboratories hospital may conduct research testing subject to the order passed by this court. Yes.
So
All
these are the 4 I have given. Your lordship will not can appoint anybody. Will not, we have suggested this 4, but will not, we are not saying that you come anyone will not of a national accreditation will not may give a test report in respect of the same machines that we have supplied to them. Let them give a test report, because what we apprehend is this, will not. This machines will not have been given to workers, Anganwadi workers. What we apprehend is this, will not, that the same strip and the same chip is not going in. That's why, will not, the results that are coming, will not, are discretion. And they are full of discrepancies, and those discrepancies, will not, are absurd.
Yes.
That's it, will not. We are not asking for any.
But kindly pass it over, my lord. Just plan it.
You take okay, I am passing it over. You inform your senior. This is the prayer. The can application 1, paragraph 27, 4 institute's name has been given, and one of the person will be appointed as a special officer. They will come and check or they will, or you can take this and they will check whether it is proper or not. That's all.
That's all. I'm not asking.
Because this court cannot decide this court is also not an expert. Correct. You are also not an expert. Your expert is denying by the petitioner. So now the independent expert is to be taken care of it. Pass it over. Or tomorrow.
My lord, not today, my lord.
Tomorrow.
Tomorrow.
Sure.
Sure.
Not good.
Thank you, Lordship.
Affidavit service filed by the petitioner be kept with the record. As per the prayer made by the counsel for the respondent, let the matter appear to be. Next. Next.
My lords, just a request on this. The can application can be served upon the respondent number 5. I have not received that.
Already served.
It was served, it has been returned.
The writ petition is there. Is it a part of that writ?
No, can.
Served, it has served, unserved, returned.
You are appearing for whom?
The respondent number 5, your lords.
Who is the respondent number 5?
Rig Nanosystems.
Huh?
Rig Nanosystems Private Limited.
Has been a private respondent, will not, whom we are apprehending is the next incumbent to get
Achha.
So it's not any other.
Okay, you serve the copy.
I'll serve it on.
You serve the copy.
Obliged. Thank you, your lordship.
Here and also.
I am for the picture. Because of Raspal, I can't reach my lord. This is a matter, my lord. This is a short matter. I was ABDB service, my lord.
Who is for the respondent?
State authority already responded, my lord. This is a matter regarding, my lord. I was participated tender before my 21st, my lord, assembly election, my lord. 21st, my lord. 2021, my lord. Then, my lord, Iloshi kindly come to page 19, my lord. That is the work order. And then subsequently, my lord, page 20, my lord.
Page
That is
19,
the
page 20.
completion certificate, my lord.
Page 19 is the work order.
Yes, my lord.
Work order issued on 25. It's
So
it's the
21st month, date of layout, completion 21st.
Work order of which year? 2020.
21. Election, my lord. Assembly election, my lord.
Where is our work order? Where is your work order?
That is completion certificate, my lord.
That is company. Where is your work order, sir?
Work order, my lord, that next page, my lord.
2021.
Yes, my lord.
Urgent
Yes,
requirement of logistic support of CAPF SCP.
Yes, ma'am. And then, my lord, partial amount has already paid, my lord, in the year 2023, my lord. But, my lord, amount of, my lord, out of, my lord, 19 lakh, my lord, they have been paid 3 lakh something, my lord. 3 lakh 28,996, my lord. And then pending amount is, my lord, 16 lakh 4,809, my lord.
Where is that?
That is, my lord,
Total figure was 21 lakh 48 2 crore.
yes, 21 lakh, my lord, 48,778, my lord.
Correct.
And gross work value 19 lakh 33,805. And partial amount has been paid, my lord.
No, where is the gross amount? The total figure kindly come to the page 23.
Gross amount, my lord, that is, my lord, page, my lord, 19, my lord, you will see kindly come to, my lord, para 4, my lord, amount put tender, my lord.
21 lakh.
Yes, ma. 21 lakh 48,000.
21 lakh, 19 lakh.
Accepted, general gross value of work done.
19 lakh.
Yes, my lord. And my lord, partial amount has been paid, my lord.
Where is the partial amount paid? What amount has been paid and what is remaining?
That is, my lord.
Where is the certificate or bill or anything?
That is my certificate, my lord. That is, my lord, page 23 onwards, my lord.
23 onwards.
Yes, my lord.
Is the total figure it is showing? Where is the payment amount? Is the price schedule?
Then, my lord, only pending amount, my lord, 16 lakh 4,809, my lord. That is my prayer.
That's why, where is the last payment was made?
Last payment made, my lord, that is, my lord, list of dates, my lord, that is, my lord, last payment made, my lord, 6/4/2021, my lord.
Which for the state?
Some order has been also passed, my lord.
Petitioner has filed.
So can you see that order, my lord?
Petitioner has filed the present application, praying for a direction upon the respondents, particularly the respondent number 5.
Can you see the order?
The executive engineer PWD Murshidabad electrical division Behrampur for release of the outstanding amount of rupees 16,04,809. Full responsible for the petition. Submit that.
The approval authority, my lord, that is Hill
6th
Council.
of April 2021. The executive engineer PWD Murshidabad electrical division Behrampur had issued the work order.
The approval order, my lord, made by respondent number 3, my lord.
The work order
Special secretary.
For urgent requirement of infrastructure and logistic support to CAPF of the SAP to be deployed at 10 numbers premises under Jalangi PS. As per the work order issued to the petitioner, petitioner has executed the work and the executive engineer PWD Murshidabad Electric Division Behrampur had issued the completion certificate on 10th of November 2025, certifying that the petitioner has completed the work satisfactorily in all respect and terms and conditions. Petition submitted, though the accepted the tender value was rupees 21,48,778.54, but the petitioner has executed the work for a total amount of rupees 19,33,805. Out of the total amount, the authorities have released. Out of the total amount, the authorities have released the part amount, and the balance amount of 16,04,89 is still pending. The petition has made several representations, but the respondents have not paid the said amount. Consider this list. Consider the submission made by the counsel for the petitioner. In spite of service of notice, none appears on behalf of the state authorities. This could find that the authorities have admitted the claim of the petitioner that the petitioner has executed the work for a total sum of rupees 19,33,805. Out of this, the authorities have only paid an amount of rupees 3,28,996 on 18th March 2024. And thereafter, the authorities have not paid the balance amount of rupees 16,04,809. Considering the above, the respondent number?
Respondent number 3 is the approving authority.
The respondent number 3 is directed. Respondent number 3
is the disbursing authority, my lord. And respondent number 4 is the, my lord, approving authority, my lord, special secretary, my lord, Home Hill Affairs. Respondent 3.
Number.
And disbursing authority, district magistrate, my lord, Murshidabad. Respondent number 4.
Number 3 is directed to immediately approve the amount of rupees 16,04,809 for payment of the said amount to the petitioner, and once the said amount is approved by the respondent number 3, the respondent number 5 shall pay the said amount. Full stop. The entire process be completed within a period of 8 weeks from the date of receipt of this order. WPN census disposed of. Next.
Well, I'm for the petition.
Yes.
Well, in this matter, that the licensing authority had issued a show cause notice 27 years after the incident. My primary case is the whole proceeding has become stale. Though Section 14 does not provide any specific time for issuing of show cause notice, but it should be a reasonable time should be constituted. I have placed Section 14D, which gives 6 months time, and accordingly, my lord, my prayer is after 6 months the whole proceeding has become stale. Now the
have you completed the custom authority?
Yes, my lord, affidavit service.
Yes, my lord, I am appearing for the customs.
May I file the affidavit?
But as the matter is too old, so the authorities takes time. And
so what do you want? Time?
Kindly
go to the record.
To gather
that. An interim order?
Yes, my lord. Paragraph 7
shall not be proceed with the interim. Okay, I am extending the interim order. How much time you require?
Okay, next week, next month.
Next month?
Yes, my lord.
Okay, you are
if in the meantime they want to file affidavits.
Okay, I am passing a direction for affidavit. You file the affidavit.
Oh, yes, my lord.
Which for the other authorities?
My lord, DGFT.
None of India?
Yes, your lordship, Mr.
Kundalia is appearing
for DGFT as well as
the customs.
So you will file affidavit?
Yes.
So I am passing an order for affidavit.
Yes, my lord. Yes.
Counsel for the petitioner has filed affidavit of service showing that the added respondents have been served. So friends appearing for the added respondent. The respondents are directed to file affidavit in opposition by 3 weeks.
No, 4 weeks, man.
4 weeks. Reply, if any, they are to be filed within a week. Within 2 weeks.
2 weeks.
Within 2 weeks. Now, list the matter. So I am fixing for hearing.
Lordship.
Yes. Especially fixed for hearing. List the matter. On 5th March 2026, under the heading, especially fixed matter at 2 p.m. The interim order is extended till 5th of March 2025.
Also, can we give few days more in case
10th of March 2026 or until further order, whichever is earlier.
Deeply obliged. 10th of March.
Next.
My pleasure, lordship, I am for the petitioner.
Yes, what is your grievance?
Lord, what happened in this matter, Lord, the petitioner is a business entity, Lord, carrying on business of retail gold jewelry.
What?
Retail gold jewelry.
Retail
jewelry.
gold. Yes.
Gold for selling, Lord, gold ornaments. Lord, the petitioner has
Bank account is seized. Freezed.
Debit frozen.
Freezed.
Freeze, Milord. And Milord,
Cybercrime case in Kerala. But we have nothing to do. I have received the complaint. I can serve him with the details of the criminal case. He can take steps in Kerala. But we have nothing to do.
Lord,
Whether the criminal case is okay, whether the have you received that they obtain any order under the 106, 107 of the CRPC?
We have only received
court for the freezing.
No, we have only received the instruction from the investigating officer indicating that debit frozen immediately.
Lord, a bona fide transaction, my lord, your lordship will find the proper tax invoice issued.
Correct, but you are having the judgment of the division. This court has none division bench of the Bombay High Court. Unless there is an order from the magistrate under the 106 and 107 of the CRPC, the bank cannot freeze the account, or the authority cannot direct the bank to freeze the account. Have you a judgment?
That is
having?
Not. I am not having the judgment.
Point number 10. Point number 10.
Debit freeze the account immediately. And whether your client has the knowledge about the criminal case?
Most probably no.
No, Miller.
No.
No.
And I can supply him the details. He can take steps.
2,80,000.
Lord, if your lordship kindly have a look to, my lord, my annexure P4, your lordship will find that Lord, at page 28. Lord, at the bottom, my lord, the lordship will find the payment summary, the UPI transaction, which is the subject of the criminal case, my lord. And if your lordship will see the, my lord, if your lordship kindly have a look at the communication, my lord, out of this 45,000, 19,000 is disputed. My lord, my humble submission before your lordship is, so far as, my lord, the transaction is bona fide, my lord, a business entity is not supposed to, my lord, conduct a scrutiny of its customer regarding, my lord, its status. My lord, this high-handed...
You do one thing. Yeah, have you copy? So
But I'll serve him a copy.
How the copy? You made this police authority as a party?
My lord, it's a party.
Who?
Yes, yes.
Who is the party?
My lord, my respondent, your lordship will find respondent number 6 is the state of Kerala, respondent number 8. My lord, everyone are party, my lord.
Resource
Bank
City.
is party.
Where is
Union of India
affidavit
is party.
service? Served.
All served, my lord. All delivered. Yes. Bank ki diyeche eta. Annexure P3 is provided by the bank.
He has the copy of this communication, page 25.
You are having the copy of this
Page
My lord, this
25 of the
communication, my lord. It's annexed, my lord.
Okay.
Annexure P.
The petitioner has filed the affidavit of service, but in spite of service of notice, none appears on behalf of the respondent, except the respondent number you are appearing for.
Bank of Baroda.
Except the Bank of Baroda, that is the respondent number.
Bank of
4 and 5.
4, manager 5.
4 and 5. Full stop. This court find that the bank has freezed the account of the petitioner on receipt of the instruction from the respondent number 8, that is the inspector in charge, station house officer within SHO, cyber crime, police station, Thrissur city, Velyanur, Thrissur, Kerala, pin code 680006. In spite of service of notice, none appears on behalf of the respondent number 8. Full stop. This court is of the view one further opportunity is to be given to the respondent number 8 to appraise before this court under what circumstances and whether the respondent number 8 under what circumstances and whether the respondent number 8 obtain any order from the court for freezer of the account of the petitioner. Full stop. Let the matter appear on 22nd of January 2026 under the same heading. The petition is directed to forward this order to the respondent number 8. Police, it is made clear that in spite of receipt of this order, the respondent number will not appear before this court on the next date fixed, appropriate order will be passed.
I'm grateful to your lordship. My lord, in the meantime, may I pray for my lord to use the bank account, my lord? Otherwise, I could not pay the salary.
That's why I fix the short date 10 days after 10 days. Because if they will not come automatically.
It's a current account, your lordship.
That's why let you wait for some time. Next.
Much
Well, Mr. Kaur is leading me in this matter. I'm in the virtual mode. Well, Mr. Kaur is there.
I understand the issue is
So the response number 2, that I don't think the petitioners would need to trouble your lordship. What they've assailed is an order of termination of a lease. I was otherwise ready to address your lordship on the merits, but my instructions are that along with the writ petition, now they've disclosed certain additional facts which were not, the authority, response number 2 was not privy to. So I will need to, your lordship will set aside this order of termination, give me the liberty to indicate to them grounds on which I may terminate. They can reply to that. We'll give them a hearing and then pass a reasoned order.
Lord, I have something to say on that. Lord, setting aside of a termination notice, no liberty is necessary because their contractual relationship is restored. And then, Lord, my learned friend can take whatever, because this leave from the court might give him some additional advantage. I tell your lordship, in short, there is a termination notice given, only forfeiture is only on account of non-payment of rent. Now, Lord, I immediately pay. The very next day, I tender the money which is credited to the bank account. Now, Lord, under 114 of the Transfer of Property Act, this is a 30 years lease with multiple, Lord, renewal. Lord, it is actually, Lord, a lease in perpetuity. I run a resort. Now, Lord, this payment was delayed. There is no doubt about it. But under section 114.
Can I just make it shorter? Then, your lordship, very well. But while your lordship sets this aside, kindly record that this will not preclude me from issuing a notice to them. I want, the effect was that I thought they would want an opportunity of hearing. Tomorrow, if this is set aside and that is not a part of the order, then it doesn't affect me. I'll give them a notice, terminating a notice tomorrow. They'll come back again. I want
it set aside. It will not preclude the petitioner and the respondents to take appropriate steps in accordance with law.
Yes.
Lord, that line, Lord, I'm really, Lord, little apprehensive.
I appreciate.
I'm little apprehensive about that line. Lord,
that is the dangerous.
I request your lordship to kindly stop, Lord, at the termination, setting aside of the termination.
In that case, I will do the one thing. If not, I am staying this order. You should file the affidavit. It will continue.
No, Lord, what has happened? 2 things have happened. The instruction to actually come forward and make this concession was on a ground. Today, the writ petitioner has come forward and disclosed. As the writ petition stands, I have a case. But now I want an additional ground because now they've come and disclosed that they have gone ahead and mortgaged state land to obtain credit facilities. They've disclosed that document here. This is impermissible in terms of the notifications of the government. So that is something that they'll have to come and explain to me.
But that's a fresh cause of action. That has nothing to do with the termination.
No, Lord, if the petitioners want to now address, this was a concession which I wanted to make because I thought they would want an opportunity of hearing to come forward.
Where is the impugned order?
Impugned order, Lord, termination notice is at page 43.
Lord, if your lordship is not setting it aside to then minded to grant a stay, then your lordship will hear me. Then I'll contest it as.
That's it. Let me see. Where is the interim order?
Lord, kindly come to page 43. Termination notice is only, Lord, forfeiture on the ground of non-payment of lease rent.
No, if that issue is gone into, then I'll address the point on maintainability.
Let's see.
Now the law is clear that these kind of writ petitions actually do not lie.
Therefore, of the persistent non-payment of breach of the primary obligation under clause 2 and 3, continue deferred despite issuance of the notice of competent authority.
Lord, 36,49,176 is the demand. Your lordships will kindly see paragraph 4, page 44.
Correct.
And this payment has been made. Your lordships will find that at page 119.
After. After
yes.
it's terminated,
Yes.
they've come ahead and paid. Now the issue is going to be twofold. This is one reason. The second, now they've come and disclosed that they've mortgaged state land. This leasehold interest that they have with me, they have mortgaged it and taken financial benefit of that.
Lord, this is a ground whether, Lord, we have exceeded our rights under the lease or not. That's a fresh cause of action. If my learned friend gives a notice,
Mr. Banyan, in that case, what I propose to do, because this is the notice, kindly come to the page 44.
Yes, ma'am.
Paragraph 6.
Yes.
So this is only with regard to the non-payment of the
yes.
correct. Now you accepted and 119. You accepted the rent. You accepted.
They have just put in the money into my account. I have not done anything. There is no overt act of acceptance on my part.
Correct.
And after termination, what is the effect of payment is something. Not also whether your lordship will exercise the jurisdiction under 226. Not, I'll tell your lordship. Otherwise, I'm ready. But my instructions were that because they have now by a letter said we are ready to make payment. The default is from 22. The amount is not so important. The fact is that you have defaulted consistently. I have had to write letters
now
to
up to
consistently
2025, payment has been made. Mr.
after
Van.
termination.
Yes,
and so now that they are evincing interest to pay, I thought the petitioners would want an opportunity of hearing, because this point is available to me as to why it should further be terminated, not about a fresh cause of action. The relationship stands determined. Now there is another additional ground which comes forward for the first time through a writ petition.
What is the ground?
That they've mortgaged this land. It's
Where
state
is
land.
that? Where is that?
I'll show that to your lordship. If your lordship looks at page, Lord, they have disclosed these documents at page 59. Please see.
Page 59.
Page 59.
Yes.
Page 59 is 11th of August 2023. They take a fresh term loan for upgradation, renovation. Please have a look at, my lord, page 61 about the fifth bullet point from bottom. And the particulars of the land which they mortgaged is at page 66. I'll come to that later. Please have a look at
61, which pair?
61, my lord, 1, 2, 3, 4. The fifth bullet point from the bottom.
All the loans.
Yes, mortgage to be created. An intimation to the Fisheries Department, Government of West Bengal regarding creation of mortgage to be done in accordance with legal search report. Up-to-date lease rental in receipt of Government of West Bengal Fisheries Department to be obtained. This mortgage, this intimation was never given. And I'll show that, my lord, page 61, 7 onwards, if you see, your lordship will find 66 onwards, the land that I give them on lease, they mortgage that. Now, please have a look at this Government of West Bengal notification.
Can I, Lord, have 2 minutes, Lord, before my learned friend, Lord, goes on to citing documents? If your lordship, please come to page 51. That is part of the lease agreement. Starts at page 49. Sorry, it starts at page 47.
Yes.
Please come to page 51. Yes. Kindly come to clause 9. Rather clause 10, which is at the bottom. That the lessee shall bear all costs pertaining to modification, civil, electric, plumbing, woodwork, in landscaping, etc., and the lessor shall be exempted from all cost itself, etc. It shall be solely the right of the lessee to develop the property as per its choice and design. The lessee shall also have the authority to arrange loans, advances from the bank or financial institutions by way of security charge or on its rights under the lease agreement. So, my lord, the point is today, Lord, if the lease agreement gives me a right, we are trying to argue on a point which is not the issue in the writ petition. His termination notice proceeds solely on the basis that there is a default in payment of lease rent. That lease rent I have made good. Lord, if your lordships kindly take the Transfer of Property Act once and come to section 114. This is a legislative scheme that if there is not a forfeiture on the ground of...
Address your lordship, I'll address your lordship on the merits of it.
Please come to, Lord, section 114. Where a lease of immovable property has determined by forfeiture for non-payment of rent, and the lessor chooses to eject the lessee, if at the hearing of the suit, the lessee pays or tenders to the lessor the rent in arrear, together with interest thereon and his full cost and suits, or gives such security as the court thinks sufficient for making such payment within 15 days, the court may, in lieu of making a decree for rejectment, pass an order relieving the lessee against the forfeiture, and thereupon the lessee shall hold the property leased as if the forfeiture had not occurred. So, my lord, after payment, I request, my lord, the Fisheries Department, which is at page 120, I request them to, my lord, withdraw the termination because of the fact that I have paid. Page 120. When they do not withdraw the notice, kindly see paragraph 4, page 121.
Yes.
Paragraph 3, 4, and 5, we say that
Demand notice was never seen.
Yes.
And the conclusion part, we have requested them to withdraw the termination notice. When they do not withdraw the termination notice, therefore, Lord, we file the writ petition saying that, Lord, no lease can be said to be pending. Because, Lord, the legislative scheme is that if there is a forfeiture on the ground of non-payment, I have a right, Lord, to tender the money to get my relief.
So in that case, Mr. Kaur, let this may be set aside.
Yes.
Correct. Let it.
Yes, of course.
If they will take steps, you raise all the points.
Correct. I am saying that, Lord, let it not be construed to be a leave granted by the court.
Not
if they at all have any right.
Granted, but not prevent the petitioner and the respondent take appropriate steps in accordance with law, and you are at liberty to raise all the points before the authority.
But the issue is that this liberty that my learned friend is asking for is not a lease in the writ petition.
Correct.
So, Lord, I presume that, Lord, the next effort would be to terminate the lease on this ground, whatever the ground my learned friend has indicated. Now, Lord, if they already have that right under the contract, because they are the lessor, I am a lessee, they can always, Lord, issue the notice of termination if they have a right of termination on that ground under the lease. Therefore, Lord, kindly do not give them something which is not, Lord. Later on, it will be said that the court has given me liberty, therefore I am issuing
my
the
lord,
notice.
may I just join issues with this submission? This termination notice, if it's set aside, and what my learned senior friend saying, this otherwise adheres to me in terms of the contract, the Lordship is not giving me the liberty. Lordship is saying that this will not preclude me from taking steps under the contract. Otherwise, the issue is going to be of res judicata. Today, termination is set aside.
How can there be a res judicata?
On this issue, I will not be.
I am not. No, I am the petitioner. How res judicata should be on my part? How can there be a res judicata on him?
Both parties will get affected. Your Lordship is only saying what is otherwise inherent in my contractual right. First, if he wants to argue, he'll
provided
have to
there is a provided
first,
there
then
is.
let us understand this. There's no point. First, then let him cross the hurdle of maintainability to show the
Let him raise
investors
the
that
point of maintainability. Let him.
I am. Then I'll cite judgment. I'll raise the point of it.
Yes,
Because this is otherwise, not all that we were saying was this notice can go. This notice of termination can go. It will not preclude me from taking steps in terms of the contract. But if the petitioner is not agreeable to this, then he'll have to come and indicate two facts. One is this is a simpliciter lease agreement with a company which is a government of West Bengal undertaking. This lease rental, what is payable, how much has been paid, and he's referring to Transfer of Property Act section 114 to clearly demonstrate that the issue arises out of a lessor-lessee relationship, which is now covered or governed by this non-statutory contract.
Correct.
First. Second, how much is paid, how much is payable. The effect of it is also a disputed question of fact. Writ court possibly under 226 does not get into it. I'll say this once more. If the petitioner is agreeable to have this order set aside with your Lordship's observation that this will not preclude me from taking steps under the contract, I will not trouble your Lordship any further. But if he's not agreeable to this suggestion, then I'll cite a decision and argue on the point of maintainability.
Lord, there is no dispute on quantum. Because as I showed to your Lordship,
whether he's agreeable to this
36 lakhs.
Whether the will not preclude, but taking appropriate action in accordance with the law.
That's right.
Under the agreement.
Seeking-
Lord,
Under the agreement, they are raising any objection.
if he has a right under the agreement, my humble submission is that if he has a right under the agreement, he can always issue a notice tomorrow. There is no difficulty. Now, why should you record my submission?
Not
I am
submission,
saying
not
you have a right under the contract. You
So
exercise that
right,
right.
your lordship will
If
protect
only-
my right. If it's
There is
getting,
no
I
question
don't
of
understand,
protection.
Manoj.
Both of us can't speak together.
Yeah.
If he has a right, he has a right. There is no question of protection of a right, because I have not come against abridgment of that right. That is not my case in the writ petition. My case in the writ petition is simple, that you have demanded, there's a forfeiture on the ground of non-payment of lease rent. I have tendered, I have paid. I am entitled to protection against forfeiture. That is the scheme of the law. And once I have paid the rent, you cannot proceed on the basis of the termination. You cannot initiate proceedings. This is the short point in the writ petition. My learned friend concedes that termination notice must go. There is no problem. I also, Lord, don't want to press my application beyond that. That is the main point. Now he says that you give me liberty to proceed in accordance with the contractual right. That right you always have. You don't need the blessings of the court. This is what, Lord, in short, I want to say. I don't want to take any more further time of your lordships.
Only thing, my lord, that I am not seeking a liberty. It's just an observation from the court that it does not preclude me from taking steps.
Your submission I will record, Mr.
Then your lordship will pass it.
And I will pass appropriate order. Let it be.
Well,
The petitioner has filed the present application challenging the order of termination of the lease of the petitioner dated 2nd December 2025. Police. Counsel for the petitioner submit that the lease of the petitioner was terminated only on the ground that the petitioner has not paid only on the ground of non-payment of the rental charges. Police. Counsel for the petitioner submitted the impugn order was issued on 2nd of December 2025, and immediately when the petitioner came to know if the amount is due, on 4th of December 2025, the petitioner has paid the amount of rupees 36,49,176 to the respondents. After payment of the respondent, the petitioner has made a representation to the respondent authorities requesting for withdrawal of the termination notice. As the petitioner already paid the outstanding amount. In spite of service of in spite of receipt of the representation filed by the petitioner, the authorities have not considered the request of the petitioner. According, the petitioner has made the present application. On the other hand, the counsel appearing for the respondent authorities has submitted that in the writ petition, the petitioner has disclosed some additional documents which were not in the knowledge of the petitioner respondents. Accordingly, submit that if this court dispose of the writ application by setting aside the impugn order dated 2nd December 2025 by giving a liberty to the respondents for taking appropriate steps under the agreement, the writ petition can be disposed. Learned counsel appearing for the petitioner raise objection and submit that the petitioner has filed the present writ application on the ground that the petitioner has paid the due amount and already made a representation for consideration of the request of the petitioner for withdrawal of the termination notice, but the respondent authorities have not considered the same. The petitioner has relied upon Section 114 of the Transfer of Property Act, and submit that once the petitioner has paid the areas of the rent, the authority cannot continue with the termination. Consider the submission made by the counsel for the respective parties. The only condition only condition, the only request made by the respondent that if this court set aside the order and the set aside the impugn order and the respondents are given liberty, comma, they have no objection for disposal of the said writ application. Considering the above, this court dispose of the writ application by setting aside the impugn order dated 2nd December 2025, wherein the agreement of the petitioner has been terminated. Full stop. Full stop. As the respondents intend to deal with the additional document which the petitioner has relied upon in the present writ application, comma, it is up to the respondent or authorities to take appropriate steps in accordance with law of the after giving an opportunity of hearing, if any, to the petitioner. Very grateful.
Kindly do not give blessings, my lord. There are many things which I could not say in the matter. Kindly do not give any blessings. But if they have any right, they will proceed in accordance with law.
Disposed of. Full stop. The full stop. If the respondents have any right to take any action, it is upon the respondents to
Much
take
obliged. Much obliged.
Extremely grateful.
Take appropriate steps. Next. 46, 47. 46 is file is not.
We have seen that. That is why. What is it? We mentioned in the morning. This matter, my lord, on the last occasion I wasn't here.
Yes.
This matter, my lord.
47.
47.
Yes.
My lord, this is with regard to, my lord, a fraud, my lord, declaration by the bank, and we had taken the point. Yes. So he wanted to make certain submissions, my lord.
I took, my lord, small recap. My lord, we have shown the judgment. They have shown the judgment of Rajesh Agarwal on the point of, my lord, my study. My lord had granted me leave for 2 days. My lord, I am here. I'll just show 2 judgments, including Rajesh Agarwal, and 2 submissions. Rest, I'll leave to your lordship, whatever my lord decides. May I start, my lord? But last day I had handed over a copy of the judgment of the Rajesh Agarwal.
Yes. Element authority. Yes. Next. Which paragraph you are relying upon, Rajesh?
Well, they had relied upon paragraph 95. I am relying on paragraph 76.
20?
76, my lord. Page number 40.
76.
Sorry, 75.
75.
As mentioned above, clause so and so of master directions on frauds
Yes.
contemplates that the procedure for the classification as fraud has been completed within 6 months. The procedure adopted under the master directions of fraud provides enough time to the bank to deliberate before the classifying an account as fraud. During this interval, the bank can serve a notice to the borrowers and give them an opportunity to submit their reply and representation regarding the findings of the forensic audit report. This was the one of the observation, and the second was, my lord, 95, to which, my lord, my learned friend had indicated. May I take, my lord, to paragraph 95 once? In light of the legal position noted above, we hold that the rule of audi alterum partem ought to be read in clauses so and so of the master direction of fraud. Consistent with the principle of natural justice, the lender bank should provide an opportunity to the bank by furnishing a copy of the audit reports and allow the borrower a reasonable opportunity to submit a representation before classifying an account as a fraud. Now the findings and conclusions are from paragraph 98. 98 itself. This is the final observation. Now, this is one thing that I wanted to highlight to your lordship, my lord. There are 2 findings, but conclusions in something else. So the providing of the entire forensic report is not mandatory. Since I have highlighted the frauds, you deal with it. They have dealt it in a reply. They have not sought for the forensic audit report. And now they say previously in 2020, we had asked for, so we now want to obtain a copy of the forensic audit report. This is their case, my lord. Now the second judgment, where since the reference to the CBI and RBI has been made, now the CBI is a necessary party. This kind of matters which are going on in high courts has been taken note by the Honorable Judge, my lord, Supreme Court in Surinder Patwa matter. May I hand over a copy of the same to your lordship, my lord? Dada.
That one.
It. But in this matter, yes. I'm not on the civil aspects. But this is not on the civil part. This is for the proposition that CBI is a necessary party to this writ petition. They should be added as a party. Why? I am just indicating the same. Paragraph 1, 2, and 3. 2 and 3. May I read it for your lordship? The RBI issued a master directions on classification reporting banks as a fraud.
Paragraph?
Paragraph 2, page number 4 onwards, my lord. Paragraph, page 5, providing a framework for the banks to enable early detection and reporting of frauds and consequently taking actions in a timely manner. In view of the same, the appellant banks initiated administrative actions that affected the respondents by declaring the company's bank account as fraudulent, an action which had significant civil consequences delineated in the master direction. The appellant banks also initiated criminal proceedings against the respondents, which with respect to fraudulent activity that was detected, as the master directions require the banks to refer certain category of cases to the state police or the CBI. As a general rule, aggrieved by the same, the respondent approached different jurisdictional high courts challenging the validity of the master directions and the actions taken consequently. The high courts, while the impugned orders have quashed not only the administrative actions initiated in the pursuance of the master directions, but also the FIR registered and the subsequent criminal proceeding initiated against the respondents. Placing reliance on Rajesh Agarwal, this judgment, the administrative actions were quashed primarily on the ground of non-adherence of the principle of natural justice, more specifically, the principle of audiotropon. As concerned respondents were not given an opportunity of being heard before the company's bank account were declared as fraudulent blacklisted. In my case, I have given them opportunity. The high courts consequently quashed the criminal proceeding initiated against the respondents, holding that they are the natural corollary of the administrative actions of declaring this aforementioned bank account as fraudulent. Thereafter, my lords, submissions are there. I'll just straight away take my lords to paragraph 13, at page 13, where the Honorable Supreme Court has classified 5 categories. 3 categories basically are 5. In which, my lord, where the FIR challenged and set aside by the High Court. Here, FIR has not been challenged, so this is not applicable. FIR not challenged, but still set aside by the High Court. Now, my lord, the consequences of the relief on the other day that my learned friend was asking for is, my lord, all consequential actions should be set aside. So this is for that portion, my lord, I am highlighting this judgment. Category 3, interim orders were passed and were not passed, my lord. Not passed, no coercive action against the concerned banks for the period of 2 weeks from the date of the passing of the judgment. Category 4, my lord.
So you are under which category?
My lord, I have referred to the CBI. I am not aware whether the investigation is ongoing or pending. This is up to the petitioner. They must be aware of the same. CBI not added as category 5. CBI not added. This is the only thing that I wanted to highlight before your lordship. Now, 2 submissions.
CBI not added because they have challenged the FIR. They have challenged the FIR. Once the FIR is challenged, the state is
simply asked for quashing of my show cause notice.
No, finally come to the paragraph 2. They have not only challenged the master direction, they have challenged the FIR and the court has set aside.
Yes.
Court is of the view if the FIR is going to be set aside, the CBI is required to be here because
but the category has
without
been
the case diary, how the court can
But here also, my lord, if my lord say, suppose, my lord, if I take today, my lord is quashing my show cause notice and setting aside all the consequential actions taken by the bank.
No consequential
that is that is the only thing that I wanted to satisfy.
Consequential action only if in the writ petition, if the court find that based on the basis of which you have issued the so cause notice and the document is not served, leaving aside the forensic report, any document not served to the party concerned, he will be prejudiced. The audio alteram paltram, it is not meaning that given the personal hearing, audio alteram paltram means only to give the opportunity so that he can place the grievances either in writing or in person.
This was the only purpose that I wanted to highlight before you. Nothing else.
Court is not going to
now coming back to Rajesh Agarwal judgment. The paragraph 76 that I have highlighted, on which I am harping, is today, my show cause notice, if suppose, my lord, if I take my lord, set aside my show cause notice, what will happen, my lord? I have to issue the same show cause notice, copy paste it. So they have replied and they have not asked for the, my lord, the forensic audit report, since I have given the excerpts of the forensic audit report where I have recorded the frauds leveled against them, my lord. But in case if they, my lord, if my lord thinks they should be provided with a copy, my lord, at the least, my lord, at least protect my show cause notice, let them file a additional reply to my show cause notice upon the inspection of my forensic audit report, because it's a huge voluminous document, my lord. This is the only submission that I want to make before your lordship. If my lord is of the view today.
You mean to say, let the so-called notice
Yes,
remain,
my lord.
you will supply the forensic report?
If it is used, then kindly allow them to inspect it.
Correct.
Kindly, my lord. Because maybe, my lord, it is very voluminous. I may be, if I provide it in the pen drive, they will say it is not working. If I say this is not legible. So these points will come and arise, my lord. Seeing the kind of litigation that are flooding into the courtroom, my lord, today. Kindly allow them to have the inspection in my presence of my officer any daytime, my lord. I am allowed. I will allow them. And take a copy, relevant portions, inspect it, find it, and file an additional reply, my lord, to that. They have already filed reply. This case is different. They have filed a reply to the show cause notice. They have not taken a point of taking, my lord, of providing this. Since there are orders being passed by this honorable court, my lord, they are rushing to the court for the copy of the show cause notice, my lord, belatedly.
But only the thing is, Mr. Tiwari, you know, one inspection of the document and sitting and going through the document, some different.
My lord, I totally bow down to your lordship, my lord. Say suppose there are 5,000.
You in the pen drive.
My lord, that will not work. I am very certain, my lord, that will not work. Giving in the pen drive or the Google link, my lord, that will not work. Hard copy will have the illegibility, my lord. So, my lord, the smallest solution that I can indicate to your lordship, I am here to assist your lordship. I know that I am in an awkward position today as a banker's lawyer, my lord. My lord, say suppose forensic audit report is of 5,000 pages, my lord. My lord, 5,000 pages doesn't contain the act of fraud. That is contained only in 10 to 15 or 20 pages.
Correct.
Now 5,000 pages.
Correct, but the last 5 to 10 pages may be continuation of the earlier.
Then kindly allow me to give it through in the pen drive and as well as a Google link, my lord. I shall share it. Kindly protect my show cause notice as on the date.
So through the pen drive, to the pen drive,
and Google link also we will mail it.
And mail to the petitioner within a period of 2 weeks from date.
Yes, my lord.
And they will.
And let them file an additional reply to the same.
No problem.
Not, my lord.
Have you filed the reply to the?
Yes. Yes.
Sorry.
I'm sorry. I was charged. My lord, he is the person who has charged me up, my lord, outside of the court.
And the other day, my lord, I left your lordship's court doing another matter. I found him on the corridors. So I told him, look, I've taken an order against you. And then I left.
Yeah, very
so after that,
last day of the vacation, I'm going to have my lunch, my lord.
Well, I must do it on the last day of the vacation.
I wasted here his lunch.
My lord, I was so tense. I had to watch the video of my lord's entire proceeding for the first half.
The problem is, my lord, I'm aging, but I can't get over all these things. My lord, I bow down to your lordship. I've not asked for any consequential orders. I think that is something which is missing it. I've never asked for it. The only thing is that, as a matter of fact, he is now wanting to stick on to his original show cause. But I think it will inure to my benefit. So let him stick on to that. I will file from that stage, my lord. Let it start.
Yes, I am disposing of the writ application.
Yes, my
I am
lord.
not touching the so cause notice.
The order will be
directing to supply the so cause.
And the order may be set aside.
Directing this,
The original, the finding, that order be set aside. Let them start from there.
What is the finding?
One of that I have been declared.
That may be stayed.
That cannot be stayed.
Where is that?
Yes, that is what I'm challenging. And that is the impugned order. Your lordship will find it.
The impugned order.
Let me have a look at mine.
Impugned order, page 60.
Page 60, my lord.
Page 60 is the
Starts from 61, my lord.
60 is the covering letter, 61 is the order starts.
Conclusion. Finding and conclusion. That's right. So this you should not give any effect or further effect.
It will start.
They file the reply.
Yes.
And a fresh order is taken.
That is what I'm saying.
Yes. I was here to protect, my lord, my show cause notice.
Also protect me.
This is the final order.
Yes, but that is.
I am setting aside this.
Yes, but can you stay till the time, my lord?
You cannot have both final orders.
I am setting aside this. Your so cause notice will remain. The reply will remain. He will give an additional.
After, yes, after his reply, I may act accordingly in
Pass
in terms of the law.
Pass the appropriate
Yes.
order. Correct.
Oblige.
Because keeping in abeyance, tomorrow you feel now my order is already there.
Only two, my lord, one small, my lord, indulgence. My lord, my submissions may be recorded.
I will record your one each and every submission.
And also,
Don't worry.
I prayed for.
I don't think that then there is any allegation that this court is not recording this.
My lord, in such circumstances, I prayed for a opportunity for filing reply to this petition.
No, he had already.
My lord, may I now if he says this, my lord, he had taken the opportunity for bringing on record that they have served me the copy. Now, when I get this report, it's a complete opposition. My lord, if your lordship, my lord, if minded, my lord, kindly see this is the order your lordship has already passed, where I was on the receiving end. So, my lord, will kindly see para 7. Yes, para 7 also. Nabad. So, senior nature against you.
The petitioner has challenged the.
But there, my lord, show cause was set aside.
No.
No.
I'm so grateful to my learned senior.
No, he was for the other side.
No, that is what he's saying. My senior has taken order against him.
He conceded that. And first time I've seen that the Mr. Ray is conceding. The petition has challenged the impugned order dated 19th August 2025, wherein the authorized officer of the Punjab National Bank has held that the petitioner account has been declared as fraud. Counsel for the petitioner submit that the respondents have issued the so-called notice. Where is the so-called notice? Issued the so-called notice.
So-called notice is at page
on 2nd of March 2020. And this said so-called notice
50
is totally based upon the forensic audit report. On receipt of the so-called notice, the petitioner has submitted a reply to the second so-called notice by taking a specific plea that the respondents have not supplied the forensic report or forensic audit report, due to which the petitioners are not in position to give the reply, though the respondents have and though the petitioner has submitted the reply to the so-called. Counsel for the petitioner submit that in the reply it is categorically mentioned that the forensic report has to be supplied with, but instead of supplying the forensic report, the respondent bank has passed the impugned order declaring the account of the petitioner as fraud. The counsel for the petitioner has relied upon the judgment in the case of State Bank of India and others versus Rajesh Agrawal and others, reported in 2023, volume 6, CC 1, and submits that the Honorable Supreme Court has categorically held that the classification of account as fraud not only result in reporting the crime to the investigating agency, but also has other penal and civil consequences against the victims. He further submit that the Honorable Supreme Court has also held that
Thank you, Lord.
that for the purpose of giving the principle, for the purpose of following the principle of natural justice, the bank should provide an opportunity to the borrower by furnishing the copy of audit report and allow the borrower a reasonable opportunity to submit a representation before classifying the account as fraud. He submits that in the present case, the respondent authorities though have relied upon the forensic report and issued the so-called notice and the impugned order without supplying the forensic report. Learned counsel for the bank raised objection and submits that in the so-called notice, the findings of the forensic report has already been stated. What are the violations has been committed by the petitioner, and the petitioner got an opportunity to give reply to the said so-called notice, the petitioner has supplied the so-called reply. And thus, further by submitting the further for supply of the forensic report does not arise. The further, the counsel for the respondent bank has relied upon the judgment in the case of Central Bureau of Investigation versus Surendra Patwa and others, passed in SLP within bracket criminal number 7735/2024, dated 25th of April 2025, and submit that the Honorable Supreme Court, while dealing of the matter with regard to declaration of the account of the borrower as fraud, has held that
May I make one submission? I'm sorry I missed it. I'm very sorry, my lord. And your lordship, in para 12 of that judgment, just above para 13, which Mr. Tiwari has mentioned, my lord, it is what has been said in Rajesh, that has been also, it says that audible alterum partem, then you set it aside.
I will.
Only that much when I should have placed, my lord.
Held that by considering the case of the borrower for declaring the fraud, the court has to the Supreme Court held that in the case of so on the Supreme Court held that the classification of the borrowers account of the borrowers as fraud is to be categorized in 5 categories. Learned counsel for the respondent has relied upon the category 5 and submit that in the present case also the case is being investigated by the CBI, but the CBI has not made as a party, and as such the CBI is a necessary party in the present case. Full stop. The learned counsel for the petitioner submit that though the Honorable Supreme Court has stated that this is to be taken into 5 categories, but the Honorable Supreme Court has also held that an audio alterum partem held that the principle of audio alterum partem is to be taken into consideration. But in the present case, the respondent authorities have not supplied the forensic report, and as such, the authorities have violated the provisions of audio alterum partem. But the learned counsel for the respective parties peruse the materials on record. This could find that the respondent bank has issued the so-called notice on 2nd of March 2020, and on receipt of the so-called notice, the petitioner has submitted the report, submitted its reply on 17th of May 2025. In the reply, the petitioner has categorically taken the stand that the respondent bank has not supplied the forensic report and requested for supply of the forensic report. But in spite of considering the request of the petitioner, the bank has passed the impugn order declaring the account of the petitioner as fraud. Considering the above, this court find that the respondent bank has not given an opportunity of hearing to the petitioner by supplying the forensic report to the petitioner. Accordingly, the impugn order is the impugn order dated 19th August 2025 is set aside and passed. Full stop. The petition, the respondent bank is directed to supply the forensic audit report to the petitioner through pen drive or through mail to the petitioner within a period of
2 weeks, Miller.
3 weeks.
3 weeks.
3 weeks, I think.
Within a period of 3 weeks.
Best, Miller, 4 weeks.
Within a period of 4 weeks from the date of receipt of this order. Full stop. On receipt of the forensic report, the petitioner is at liberty to file their supplementary reply to the so-called notice within a period of 3 weeks.
Yes.
Within a period of 3 weeks. Full stop. And on receipt of the supplementary reply from the petitioner, if any, against the forensic report, the bank shall take appropriate pass a reasoned and speaking order within a period of 3 weeks thereafter.
My lord, will kindly consider para 7 of NABARD, my lord. Only that much. If we feel that there are certain other documents required, my lord, your lordship had made a provision there.
Full stop. It is further made clear that if the petitioner intends to find that the further document has been relied by the respondent bank and then the same has not been supplied by the respondent bank, comma, immediately within a week from date, the petitioner shall inform the bank and the bank shall supply the said
Along with the
forensic report.
And my lord will kindly make that 4 weeks for us also.
For what?
The
The
reply.
filing the reply.
reply. Supplementary reply within 4
4
weeks. Supply of forensic report 4 weeks. Supply of supplementary audit for supplementary reply 4 weeks. The authority shall take appropriate steps pass reason in speaking order within a 4 week thereafter.
I'm grateful, my lord, for giving me such an opportunity to study at least the law. I'm obliged.
Thank you. Thank you. So your skin is safe. Dispose of. Next.
My lord, item 48, my lord, I appear for the petitioner. My lord, kindly allow me to appear virtually, my lord.
Yes.
Am I audible? My lord, I had moved an interim, this writ petition and paid for an interim relief, my lord. On 19th of December, my lord had heard and by detailed order, my lord had refused an interim relief to me, my lord. So, my lord, I have to come and argue the writ petition, my lord.
Yes.
My lord, I'm being led by Mr. Anuj Singh in this matter.
Yes.
I
Where is
appear for
Mr.
the
Singh?
petitioner.
Where is Mr. Singh? Just he was there.
I'm sorry, I can't hear your lordship. My lord's voice is breaking. I'm really sorry for the
Where is Mr.
inconvenience.
Singh?
My lord,
Yes, Mr. Singh is here.
Am I audible now, my lord?
Yes. Yes.
My lord, I'll have to argue the writ petition, my lord. Kindly, my lord, fix any date, my lord. I'm not there today physically, my lord. I'll come and argue it, my lord, any day, my lord.
Whether affidavits filed not.
My lord, they have not filed any affidavit, my lord. If they wish, my lord, they can. But, my lord, I am
Which
otherwise.
for the respondents you are appearing. So you will file affidavit or without affidavit it can be disposed of. If you say you will not file affidavit, then I will fix a date for hearing. Yes. Take.
The project is for the public interest.
Correct.
Only up to the apex court, there is no any fruitful order, my lord.
Court has not passed any interim
Yes.
order.
Yes,
So
my
that's why now writ petition is to be disposed of. Whether you will file affidavit, if you will not file affidavit, I record your submission, I will fix the matter for hearing.
The file the affidavit
How soon?
within 4 weeks, my lord.
4 weeks.
In the meantime, my lord, kindly see the letter, my lord.
My lord, let them file their opposition in a shorter time, my lord, because they want to delay the writ petition and then proceed against me. This cannot be done. My lord.
Already your lordship's order, in persons of that letter, your lordship order clearly violated, my lord. At this stage, there is no any interim order.
Correct.
But
Okay,
kindly see.
whatever it is you want to file, you file the affidavit in opposition within 3 weeks.
Yes.
The counsel for the respondents is respondent state for time to file affidavit in opposition. Let affidavit in opposition file within 2 weeks, 3 weeks. Reply by 2 weeks.
2 weeks, my lord.
Reply
2 weeks.
2 weeks thereafter. Please the matter. 3 weeks, 2 weeks. Yeah. February में कौन एक डेट दे दो 2 बजे 10 तारीख के बाद दो after 10th February any date at 2 p.m. (11th February at 2 p.m. as a specific.
Very well, man.
Grateful.
Next. Next.
Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, this is a tender matter, Lordship. Affidavit of service, Lordship. Lordship, I have challenged the terms and condition of the tender, Lordship. Lordship, first thing, Lordship, this is a tender for supplying of food to the borders of Bengal.
Supply of
food.
Food.
To the border of Bengal Football Academy. It's a tender contract period for 3 years, Lordship.
Correct.
Lordship, first thing, there is nothing has been mentioned as to how many border will be there. To how many borders I have to feed, nothing mentioned, Lordship. It has not mentioned the tender value. What will be the tender value? That has not mentioned, Lordship.
So you challenge the tender notice.
Terms and condition of the tender, Lordship.
Where is the tender notice?
Lordship, page 27, Lordship.
Page 22.
27, Lordship.
27.
27 onwards, Lordship.
Director of Youth Services. Director of Youth Services.
And Lordship, the main point is, Lordship, that...
Where is the name of the work? Supply of food for the borders of the Bengal Football Academy.
Lordship, 28, Lordship. 29, Lordship.
Yes.
The Department of Youth and Services and Sports under Government of West Bengal, represented by the OSD Secretary, Government of West Bengal, e-tender from reliable, resourceful, bona fide, registered agency, registered firm, company having at least 3 years of experience, such and such, for quoting annual rate of supplying food for the borders of Bengal Football Academy on operational contract for the premises Vivekananda Stadium. Lordship, stadium name is wrong. Anyhow, the detail of chart has been given. So, how many borders will be there? That hasn't been mentioned, Lordship. No pre-bid meeting has been.
That cannot be. Borders.
I'm just highlighting this thing. Lordship, I am mainly challenge the terms and conditions. Lordship, kindly the rate chart. Lordship, kindly come to the rate chart, Lordship.
Where is that?
Starts from page 41, Lordship. Lordship, first, Lordship, I shall rely. Page 44.
44.
44, 45, Lordship.
Correct.
Lordship, that has been mentioned, Lordship. First column, Lordship.
45.
45.
Correct.
Breakfast. Second column. Oats, produce with chopper, appeal, oats, such and such. One big glass. Next.
Yes, one grain bread plus 4 pieces, 1 teaspoon.
Plus second, Lordship.
Peanut
Oats.
butter.
Oats. Lordship, second oats.
Where is
That has
yes,
second
oats,
column.
oats. Yes.
One big glass, Lordship.
Correct.
Next, Lordship, rice. One medium bowl, Lordship.
Correct.
Next, Lordship, I'm not skipping. Thereafter, mention one medium bowl, Lordship.
Correct.
Thereafter, one big bowl, Lordship.
Correct.
It has mentioned, but list of other places.
Yes, there are 450
Yes,
gram.
that-
Kindly
that's
come
what-
to the-
that's exactly
In
complete.
Lordship, other places, Lordship, kindly. Lordship, page 41 onwards. This is also chart.
41.
Lordship.
Yes.
Lordship, meal, Monday, and breakfast, Lordship. Muesli, one bowl. Not mentioned.
What?
Lordship, muesli. Lordship, next, breakfast.
Monday.
Second column, breakfast, 8 a.m. to 10 p.m.
Correct.
Whole grain. Next column, Lordship, muesli. That has been mentioned. Next column, muesli.
Muesli, yes, one bowl.
Not mentioned. How big, small, medium, not mentioned, Lordship. How you will quote rate? Other place, Lordship, it has mentioned medium, big, small, not mentioned. Lordship, now come. Lordship, 1, 2, 3, 4, 5, 6, 7. Last but one, Lordship. Lordship, I'm sorry.
Muesli.
Not,
dal.
Lordship, next, 42.
42.
Third column,
Yes.
veg soup.
Third column.
First, second, third, cereal. First, second, third.
Green salad.
Lordship, not that. Chicken sandwich, chicken soup, veg soup.
Correct.
One bowl.
Correct.
Whether big or small, I don't know. Lordship, next column has mentioned medium bowl.
Correct.
But in the here not mentioned, Lordship. And Lordship, kind to bottom, Lordship. First, second, third, fourth column, order dal. One bowl. Not mentioned big or small.
You are moving this writ application at 120. The
No,
court,
Lordship, for that I have to.
court is hungry now.
No. Lordship, that is
Mullah,
true,
this
Lordship.
is not-
Lordship,
but he has
quoting,
also
I have
said
to
it.
quote
You,
rate.
you are mentioning the chicken sandwich, chicken soup. and
Lordship,
all
so
these
many
things
views.
at 120.
Lordship, there is no second. Lordship, at 2 p.m. I shall come back. I shall come back.
Okay, okay.
Lordship, I am challenging this. Lordship, how I shall
So
quote
what
that?
is your grievance? The quantity, quality,
Lordship,
quantity has not been mentioned.
mentioned.
Nothing more
What is
than.
the thing?
Mullah,
Next.
Lordship, that is the thing, Lordship. This is the thing, because I have to quote straight on the basis.
Kindly page 6.
Page 6.
Of the petition.
Page 6 of the writ petition.
Yes. What are the discrepancies he has mentioned here? Page 5 and 6. Kindly see it.
Correct.
Kindly come to lunch. Monday, 450 gram, raw rice or cooked rice. But I don't know whether raw rice is given to the players or not.
I'm not that.
No. You have mentioned this. Raw rice or cooked rice.
I am not placing
Well,
that,
this
Lordship.
type of
That may be in the list.
It should not be cooked rice, it should be boiled rice.
Yes.
It's mentioning
Lordship.
whether it is a boiled rice or raw rice, not the cooked rice. Boiled rice.
Yes, my humble submission.
You do one thing. You take.
No, they have participated in a meeting.
No, Lordship, there is no pre-meet
The
meeting.
tender is open.
No, Lordship, not.
Tender not open.
Not.
They have participated in a meeting.
No, Lordship, there is no pre-meet meeting. Lordship, kindly turn the schedule, Lordship.
Just a minute.
No, I'm
You take instruction, come with the report with regard to these discrepancies, which what is ball. That's correct.
Yes.
Ball is a small ball or big ball.
No, big means there must be size.
Yes,
1
there
foot
are
or 2 foot.
There are you are not mentioned here.
Yes.
Tomorrow, if you given the borders with
Yes.
regard to the small bowl, then
Yes.
they will say that the small bowl and he will charge this big bowl. So it will be
I
difficult.
should file a report.
Come a report or clarifying that this is clarifying that. So let
Subject, there is no pre-bid meeting.
No.
you that also take instruction. If
Yes.
it's a meeting, there will be a minutes of the meeting
Yes,
signed
sir.
by the petitioner also. How soon you will file and whether tender is open or not.
No, Lordship, today
That
is
I
the
do
date
not
for
know.
opening technical bid.
Today is the technical bid open. So what can be done? Today is the technical bid. You have submitted your technical bid.
No, Lordship, I did not participate. As I have challenged the terms and conditions of the tender, Lordship. That
Bid
is,
opening is 13 January. Yes, today, 11 p.m. That already been open.
Yes.
Lordship, financial bid has not opened, Lordship.
That I do not know. I am not.
Lordship, that is the chart, Lordship.
Technical is that today. Unless and until you will not qualify the technical, how you will go to
Yes.
the
So, Lordship, I
financial?
did not participate. So, if I
You are not participated.
No, Lordship.
So
Lordship, so Lordship, I have challenged the terms and conditions. If I challenge,
No, you have not.
Lordship,
Unless you
you
participate.
not participate.
You have not participated. How can
why,
it be
Lordship,
so?
why? As I have challenged the terms and conditions, I cannot participate.
But that is why he
Because,
did not
because I have challenged the
participate.
terms and conditions.
Because he will not
Terms and
participate, others
conditions
will
is
not be
so
allowed to be
manner-
participated.
So I cannot participate, Lordship.
No,
because
no.
how-
Others will
Lordship,
not be allowed.
Just a minute. One person can
Lordship, how I can quote rate? That is the thing that I have challenged. I have
So when
filed
you file the writ application
December, Lordship.
and not able to move the
Lordship, I have mentioned it, Lordship. Lordship, I recollect. Your Lordship said that it will be appear as urgent motion, but don't know when it will be taken up, Lordship. I requested Lordship to take up before
So today
9.
is the last date. What can be done? And you're not participated. If
Lordship-
it's supposed to, if it is the court is held, so what is your grievance? You're not participated.
Lordship, one thing, Lordship. If I participate, this petition will become infectious, Lordship. Because challenging the
So
terms and conditions, I cannot participate.
You couldn't mention the separate rate of 3 ball.
Lordship, I cannot participate because I have challenged the
You
terms.
could have been mentioned.
Lordship, that will be rejected. Because it's a e-tender. That will not accept it. It's a e-tender. That will not accept it in their portal. That is the predicament, Lordship.
How you are going to accept, because without mentioning the size of the bowl? How your authority will accept? Which size of the ball your authority will accept?
Normal size, I
And
understand.
11 p.m. 11 p.m.
Hmm.
11 p.m.
11.
11 p.m.
That has been
Your office is working at night.
11 p.m. That has mentioned, Lordship.
Page 31.
31.
31, 11 p.m. opening date. Bid opening date of technical proposals online, 11 p.m.
So then it's certain open, Lordship, till now.
I understand. Oh, 1 p.m. because 12,
1
12.
p.m. No,
It
11
might
PM.
be. Might be.
No, Lordship.
Because
Lordship,
bid submission start 11 p.m.
Lordship.
That kindly clause 4.
All PM, Lordship.
Clause 4.
All PM. 1
PM.
5 PM, 2 11 PM, 3 5 PM, 11
Right.
PM, 5 PM.
Yes,
11
yes. I
All
found
from
it.
PM. So it has not open.
What can be done?
Very difficult to say, my lord. I have to get instruction, my lord. Yes.
December, he has served you copy. You are not
Lordship.
copied the total instruction.
I have to take instruction.
So for the time being, you not to proceed with the tender.
As your lordship. My lord, may I?
Nobody is giving there to give instruction to you.
Yes. No, 11 p.m. my lord, I have not seen it. First.
All are PM.
All are 11 p.m. আপনি এটা লেখেননি তো?
The petitioner has filed a
তো আছে, আমি আলাদা-
application challenging the tender notice for supply of food for the borders of Bengal Food Academy. Bengal Food Academy at Vivekananda Stadium.
Yes, yes, yes.
At Vivekananda Stadium, Rahara, Kharda. Please, counsel for the petition submit that. That in the schedule, in the
tender notice means Vivedananda.
in the
Vivedananda.
annexes, comma, the authorities have in the tender, it is mentioned that the mostly MUESL mostly is to be supplied, but it is only mentioned one ball. But the authorities have not clarified whether it is small, medium, or big ball. Like this, the and another, where is another one?
42 page, Lordship.
42, which page?
Lordship, masala oats, 1 bowl.
Another, the masala oats, 1 bowl.
Ahad dal, 1
Also
bowl.
not clarified whether it is a small, medium, or big one. These are the two.
Lordship, ahad dal, Lordship, 1 bowl. There is so many.
Like full stop. This court find that today is the last date of the opening of the tender of the technical proposal online at 11 p.m. 11 p.m. Full stop. This court find that the tender notice has not clarified with regard to the size of bowl. And the authorities will accept the tender. Accordingly, for the time being, the authorities are directed not to proceed with the tender process till the next date of hearing. In the meantime, the authorities are directed to file the report by way of an affidavit. Let the report be filed by
My lord, today is next Wednesday.
by 21st of January 2025.
31st of January.
21st.
20, yes.
21st January 2026. After serving the copy to the Land Council for the petitioner, let the matter appear on 21st of January under the same heading.
21st January.
Lordship, may I file a supplementary affidavit? Lordship, my credential has been mentioned here wrongly, Lordship. That has
No,
been...
no, my lord, that is not the
The
subject.
affidavit filed by the petitioner be kept with the record. The petitioner directed to supply the supplementary copy.
Lordship.
Affidavit to the petitioner.
I draw your lordship.
Much obliged.
I was the advocate on record, but there are 5 names. Those are not the advocate in this case. As today, I received the copy of.
Come tomorrow. Mentioning at this stage, it is not.
Item number 50.
This matter, Millet, in fact, it was fixed at the instance of Mr. Bhattacharya, Millet. Millet, he is Millet on Lake Millet in a death reference matter. It will continue for a day at least.
No, the arbitration proceeding is been stalled. That is the only difficulty.
Yes.
No voice indicates that not want to do the matter.
So, when?
Milord, kindly keep it tomorrow in that instance, Milord.
It may not.
Can't be fixed.
May not be time, but at least up the list so that we can get an
Tomorrow.
opportunity to proceed. I am for the respondent. Then day after tomorrow.
For a week, I believe it's a continuing
Let Mr.
matter.
Bhattacharya begin. The only prejudice, Milord, I am facing is my arbitration has been stalled, which is pending before the learned MSME.
I understand, Milord. In fact,
Before the
MSME.
MSME.
MSME, Milord.
Now,
The
Milord,
jurisdiction was challenged.
What is the interim order here?
Jurisdiction was challenged.
There is
Milord,
an order of stay.
yes, and Milord, all Supreme Court judgment was cited. That comprehensive, in fact, a detailed hearing was done. Milord. Thereafter, the order was passed. Milord, last 2-3 orders, Milord, will be reflecting all this. Milord.
But there is a stay which is pending since
Yes,
2024. I am prejudiced because of that.
Can you extend the interim for 2 weeks?
Sir, the Supreme Court decided the issue.
No, not yet.
But I am not on that point.
Ultimately, Milord, I have to place that also. Milord.
There is efficacious remedy jurisdiction section 16. Your lordship has taken up this determination for quite some period. The concept is same as section 8 of the Arbitration Conciliation Act. My argument would be very short. That is the reason why I was beseeching, let it be up the list so that at least some hearing can begin.
Raised for time due to some personal difficulties. Learned counsel for the respondent number 3 and 4 submit that due to the interim order passed by this court, the petitioner, the respondents are facing difficulties. Consider the submission made by the counsel for the parties. The case is adjourned. Let the matter appear on 22nd.
After 26th minute.
After 26.
Right.
Then in February I will fix a date to hearing. कौन सा 2 बजे कोई फ्री है देखिए फरवरी में.
February to दादा एक तो देखते हैं.
February
if a date is fixed.
Ryan, don't fix the time at the top. So that I can communicate.
If it is going to February, then even if it goes to the end of first week of February, lordship can keep a date with a time.
That's what I'm telling.
Yes.
Time দিলে মুশকিল হচ্ছে যে স্যার না থাকে আবার
দেখুন একটু বলে দেখুন. I have been very candid with my predicament.
No.
Already fixed. 12 and 13. Before that, there is no date. Already fixed. Before that.
এমনি
9th February, 2 p.m. 9th February, 2 p.m. It's especially fixed matter.
Kindly extend the interim order.
Interim order is extended till 9th February 2026 or until further order, whichever is there.
I'm obliged.
Yes. Next.
I'm for the petition.
Who is for the respondent?
Mr. HON'BLE Sen is appearing in this matter. Actually, this matter was due to appear on 13th February.
13th February? Yes, 13th February 2 p.m. Okay, I'm not taking. 13th February 2 p.m.
Mr. Sen is here.
13th February.
13th February.
Already fixed on 13th February 2 p.m.
Yes,
I don't know how it has been listed.
Lord's is order dated 24th of December.
I have seen. 13 Yes, next. Next.
Next, I'm Tedike. That is with Mindapur Bar Association matter, election held, and 3 candidates are petitioners there. Difference is such, no impact. But
they will not come.
Here. And don't dismiss it. Another chance may be given to them. And in the meantime, my client, the president of the Bar Association, passed away. By name, he is there. So, new incumbent has to be there.
Okay, I am simply adjourning the matter. The Learned Council for the respondent number.
I am for the
4 and 5. Learned Council for the state and the respondent number 4 and 5 are present. None appears on behalf of the petitioner. Council for the respondent number 4 and 5 submit that. The who died? Respondent number?
President, the respond briefed out only.
President 5. By it is by not by name.
One is by name, probably. If it is not by name, no problem.
It is not by name.
Then not necessary.
It is. क्या बोला?
Yes, okay. बोलिए patient by
None
name.
appears on behalf of the petitioner. For the interest of justice, the case is adjourned. Let the matter appear.
Any just no urgency. This is the result has been published.
Let the matter appear on 17th February 2026. Under the same heading. Yes, next. Password 23.
First, I apologize, my lord. I could not calculate the code operation. Suppose that
It's okay.
this is a matter. This is a wetland matter. I tried to ring up everybody. Some of them in Ganga Sagar or some of them other. But this is many matters. Sir. I am ready, my lord.
Who is for the authorities?
Because there's many, some Advocate General, some Sonam Singh is there. They may not be here. Sonam Singh, she was
So what I propose, I am fixing in the month of February as a specially fixed matter.
That will be
That
better.
will be better so that you can notify the all parties.
Yes.
The matter can be taken up.
Yes,
for you.
only interim order, the electricity
Interim
condition.
order, I am extending that. Give the interim order.
That will be better because but I made one no complete notes of argument for all the matters.
Because AG is also appearing here.
Yes. And if you say at 2 p.m. or Jaman Sajid Lordship, I'll do it. It takes some time, my lord, because
Counsel for the petition is present. None appears on behalf of the respondents. Full stop. Affidavits filed.
In some matters, evidence are filed.
Full stop.
So, but there's also point of law.
This court finds that the matter is to be heard on merit. Accordingly, case is adjourned. Let the matter appear. February में देखिए second week, third week में कोई date 2 PM 2 बजेगा.
11 the circuit starts before that. I'm not. Well, today I'll go back again.
Like officer check the diary.
Yes, subject to lordship. I know, my lord. I mean, always moving and ultimately I have to stay there. I have understood that.
जिसमें कोई मैटर नहीं होगा ना वो डेट
It takes time. Nine.
19th February खाली है?
No holidays.
19th February है? खाली है. 19th February at 2 PM as a specially fixed matter. 19th and 20 I am fixing.
Yes, yes.
19th and 20th
Yes,
February.
that will be better, Mal. I'll give the notice.
And 20th February 2026 as a specially fixed matter at 2 PM. Full list of the petition is directed to inform the
all the
date appearing to all the learned advocate appearing for the respondents. Next.
Sorry, I again apologize.
Interim order is extended till 20th February 2025 or 2026 or until further order.
I'm sorry for my junior. He said I don't know. Sorry, man.
No, it's okay. Next. No, 49.
Item number 50.
Yes, call the
If
50.
it is the last date of submission of the form. I have got the name of the learned council for the respondent. My name is not appearing in the voter list because they are not issuing the forms.
Which item number 50?
50, Lordship.
File is not.
File pensioning slip is here, but unfortunately
file is not there.
Yes, Lordship, kindly take it tomorrow at 10:30.
Not today, not today.
Tomorrow at 10:30, Lordship.
10:30 I cannot say, not today. If the file comes, then we'll see to that.
File is here, my lord.
It will be tomorrow.
It will be
tomorrow
but
late.
Kindly, Lordship, kindly give some precedent. I will give notice, Mr.
You issue notice, it will be listed as urgent motion. I cannot fix it 10:30, sir. Yes, next.
Lordship, my senior, Mr. Vimal Kumar Shahi, is for the state and I am led by Mr. Vimal Kumar Shahi.
Who is for the petitioner? Board is not working. Yes, 51.
51 I appear for the petition.
Yes. Dismiss. So you are not appearing?
No, my lord, I heard my lord 50 minutes.
51.
Yes, my lord, tender matter, my lord. My lord, what happened, my lord? We participated, my lord. 3 of the bidders, my lord, became L1. Now, my lord, there were provisions.
3 of the petitioners, parties are the L1. How it can be?
3 persons became L1.
How it can be?
Yes, my lord, they bidded the my lord same rate.
Same rate.
Same.
Okay.
So, my lord, 3 were declared L1. Now, my lord, there were 6, my lord, 6 service were provided, my lord, were to be provided, 6 security personnel. Now, my lord, every bidder was given 2, my lord, equally distribution of work. Now, my lord, what happened, my lord? When it comes to the return of the petitioner, my lord, they are being instructed by the authorities, my lord, to take 2 personnel who are their personnel. My lord, nowhere in the tender terms, my lord, it says, my lord, their persons has to be taken. If your lordship will, my lord, takes up 110, my lord, your lordship will find that communication, my lord.
110.
Yes, lordship.
Report.
Yes.
The office of the undersigned, my lord, it is addressed to the petitioner. The office of the undersigned is requesting you to deploy the following manpower as proposed recommended by the MLA. So and so. The names and mobile numbers of the 2 candidates are so and so, so and so. My lord, the Chief Medical Officer of Health, Bishnupur Health District. My lord, this, my lord, they cannot do under the tender terms and conditions. They cannot recommend us to take their personnel. My lord, previously, my lord, we have intimated them, my lord.
So what you have done after this?
My lord, after this, my lord, work order has been issued. My lord, kindly see, my lord, page 113.
On the very next.
On the very next day, my lord, 18th December, my lord, this has been issued. But, my lord, on the terms that those 2 persons has to be taken.
Where is that?
My lord, the previous page.
Not in the work order.
Not in the work order. My lord, this is the difficulty that I am facing. My lord, that is why I am challenging this document as page 110.
110 you are challenging.
Yes.
Yes. Where is the tender document?
Tender document. My lord, tender document is at page 118.
118.
No, only
18.
Yes.
it starts from 18.
My lord, your lordship will find, my lord, that communication, my lord, 2 personnel were to be deployed by 3 persons. It will be appearing at page 73.
Page
73, my lord.
is?
Yes, my lord, the award of contract. Your lordship will find the name of the 3 L1 bidders. My name is appearing at column number 3. Task Facility Services.
Yes.
Now, my lord, in the rate column, your lordship will find number of security personnel unskilled to be engaged 2 each.
2 each, yes. Yes. Period of supply 23-28.
Yes. Now, my lord, your lordship will find, my lord, at page 76, this is the agreement. This has been entered into between the respondents and the petition.
78.
See.
Yes. Unit price per head 583 per head. So what is the minimum wages in the Calcutta?
That is there.
It covers the minimum wages.
Yes, yes, my lord, then my lord, they will not give us the work. That is the condition. Lord, kindly takes up.
Okay, that this is the only grievance.
Yes.
Yes, sir.
My lord, allow me to submit my expenses. My lord.
Yes.
My lord, please come to the paragraph number 3 onwards, my lord. Everything will be neat and clean.
Already accorded prior administration approval. No problem. 6 security person. No problem. Pursuant to the 14 bids were received. Upon opening, 3 bidders, namely so and so and so. According award was conducted, L1 bidders to submit performance. Since there was a L1 bidders work distributed among the 3 category agencies. Even it. Whereby 2 security persons were allotted to each agencies. Correct.
Thereafter, my lord, this writ petition is not my document, my lord. It is the document of the petitioner side, my lord. Please come to the page number 112, my lord.
112. Yes.
Dispatch cell CMOH office Bishnupur HD Bishnupur Birbhum pin so and so, my lord.
Correct.
Thereafter, please note, please do not send the reply of letter in this email ID. This is only for the central dispatch cell. Bishnupur HD. If required, please send the email as mentioned in the official letterhead, my lord.
Correct.
But the petitioner in his document sending the emails to the concerned authority on this email ID, my lord.
Correct.
Then he is not trying to connect with us, approach to me, my lord.
You tell me, can you said that only these 2 persons can be deployed?
My lord, why not?
Huh? You can. You can say.
No, I can.
You have published the tender of supply of the manpower.
My lord.
You have ordered the contract.
My lord.
The contractor is having their own workers.
My lord.
So can you say not these 2 persons to be deployed? Of your person can be deployed. Why you have published the tender? MLA will please. MLA will see. Yes, these are the 2 persons is to be deployed instead of the contractor. Record an order.
My lord, subject to your correction, if petitioner is not eligible to supply.
How the petitioner can you are telling that this 2 person is to be employed. So how the petitioner can be?
When I say, my lord, being a chairman, I am the chairman of the municipality.
Who?
I am.
Who are you?
Petitioner is mentioned.
So chairman can do anything about the contract. Chairman, there is a show me in the contract. Yes, chairman has the right to identify the person who has to be employed by the contractor.
There is no authority to the chairman. But subject to your correction, my lord, it might be. It might be. I am not sure, my lord. That when the petitioner is not eligible to provide the security guard,
Sir,
I have suggested.
When the work order was issued? When the work order was issued? Tell me. He has not supplied your contention. He has not supplied. When the work order was issued?
It was issued on 18th November.
Kindly come to the page 110. Kindly come to the page 110. What is the date of the letter of the MLA?
17th.
Then
December.
Before issuing the work order, you identify the person to the contractor. You supply this person. How the contractor will supply the person?
My lord, after 1 month.
You can I record that you have not written that this person will not be required to be deployed. He can deploy the another person. I will record your submission and I will say,
my lord,
with conscious give the answer.
If the dispute is arising,
not dispute. I am asking 1 question, 2 question. Can the MLA will force the contractor to deploy these 2 persons? 1 thing. Second thing, whether you tell that yes, you are not harping upon these 2 persons, the contractor may deploy any 2 persons. Give the two answer. I am disposing of the writ application. Otherwise, your MLA is to be appear before this court.
My lord, I am agreed with second one, my lord.
Second one.
My lord.
That things have been issued by the CMOH on the recommendation of the MLA.
But my lord, there must be a time frame. Within such and such period, he have to provide. My
He will provide tomorrow itself, day after tomorrow itself.
My lord, please record it.
Give it him.
By tomorrow he has to.
The respondent authorities have published the e-tender notice for providing of security services for CMOH. What is the capital? In the office of this Chief Medical Office or of the Health, Bishnupur Health District. Police. As per the e-tender notice, petitioner has participated in the said tender. On opening of the tender, it was found that 3 bidders have quoted the same rate. Accordingly, the respondent authorities, that the Chief Medical Officer of Health, Bishnupur, has awarded the contract to 3 bidders, including the petitioner, for providing the security, providing 2 security personnel each. 2 security personnel each. Full stop. After the award of the work dated 22nd of September 2025, the Chief Medical Officer of Health, Bishnupur, had issued a letter dated 17 September 2025 to the petitioner, informing the petitioner to deploy the manpower proposed / recommended by the MLA Bishnupur and Chairman, Bishnupur Municipality. After the issuance of the letter by the CMOH dated 17 December 2025, the CMOH had issued the work order to the petitioner on 18th of December 2025. Consequently, the petitioner submitted there is no condition in the tender document or in the work order that a specific person has to be employed by the petitioner. Consent for the petitioner submitted, the petition is having its own manpower, and he has to deploy 2 persons for the security person as security personals in the office of the CMOH Health. But the respondent authorities have pressurizing the petitioner to engage 2 persons which names have been recommended by the MLA, which is not in accordance with the tender, which is not in accordance with the terms and conditions of the tender notice. Learned Counsel appearing for the respondent authorities have submitted that an email has been sent to the petitioner.
Page number 112, my lord.
Petitioner, by informing that no email be sent to the authorities in the email address. What is the email address? Dispatch cell CMOH Bishnupur. देख लेना. Yeah. But in the said email, and in the email dated 17 December 2025, it was informed to the petitioner if any correspondence is to be made, that is to be made through that in the official letterhead, in the email address, ये वाला CUMH, this one आएगा, ये second आएगा. Had the learned counsel for the respective the learned counsel for the respondent submitted that the other 2 bidders have already provided the security personals, but till date the petitioner has not provided the security person in terms of the work order issued to the petitioner. Had the learned counsel for the respective parties, this court find that the work order has been issued to the petitioner on 18th of December 2025, directing the petitioner for providing 2 security personals. in the DRS office of the CMOH Bishnupur, Health District Bishnupur, Bankura. But prior to issuance of the work order dated 18th of December 2025, the CMOH has, by a letter dated 17 December 2025, requested the petitioner to deploy the two persons whose name has been recommended by the MLA Bishnupur and Chairman Bishnupur Municipality. This court has also considered the terms and conditions of the tender document as well as the work order. There is no condition in either in the tender document or in the work order that the authority will specify or identify or propose the name of the persons to whom the petition has to deploy. But in the present case, the CMOH requested to deploy two persons whose name has been recommended by the MLA. Considering the same, the request made by the CMOH for deployment of the two persons recommended by the PML is without any jurisdiction. Accordingly, the letter dated 17 December 2025 is set aside and quashed, the petitioner is directed to immediately execute the order, work order dated 18 December 2025, deploying the two security personnel in the office of the DRS CO and DRS office of the CMOH, Bishnupur Health District, Bishnupur, Bankura, from on and from on and from 15th of January 2026. The WP is disposed of. The report submitted by the respondents, we kept with the report.
Deeply obliged, my lord.
Next.
Lord, I appear for the state led by Learned Adult also.
28 January.
28 January.
On 8 January, it was passed by the
Come on, 28 January.
22.
Obliged.
As per the, where is the order? You are having a copy of the order? Keep the copy of the order.
But every service.
Same order? Same matter?
Same matter related to Bar Council election.
Keep this. What can be done?
Every service was
Come on that. Keep it that and take the note.
Kindly mention that wrongly it has come.
Record. This court find that by an order dated, what is the order dated, sir?
8 January.
8 January 2026. This court has already fixed the matter on 28th of January. Any time is fixed? No.
No, madam. 28th January along with
under
another.
the urgent motion. Let the matter appear on 28th of January 2026. Under the same. Next.
I am deeply obliged to Lord. Led by Learned Adult.
Give the name.
I'm given.
Lord 53, I'm appearing on behalf of the petitioner, my lord. The clients in this case, they do not want to continue with the case. Kindly gives me 2 days, my lord. I'll get the written instructions from the clients, my lord.
Not as per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 20 January under the same heading. Next.
My lord, I'm appearing respondent number 2.
Give the name.
I am appearing on behalf of the West Bengal Power Development Corporation.
Clients don't
I'm
want
filing
to
by affidavit in opposition.
Affidavit in opposition filed by respondent number.
Respondent number 1.
Respondent number 1. Be kept with the record.
My reply as well.
54.
वही था पहले वाला जो वाला
4.
54 है you are
53 তার আগে ছিল he was, I think we have all dislodged.
53 you're asking time.
Yes,
na?
yes. No, my lord, I asked for time for, yes, my lord. Just kindly give.
53
Yeah, 53.
53 you are appearing.
No, I am for the petitioner.
Yeah, I'm responding number 2.
But yes,
you are asking time.
Yes, my lord.
So I am adjourned on 20th January.
Yes,
okay.
Grateful, my lord. Great.
Look, on the 54.
54 your lordship. I have not received a copy of the reply.
Yes.
No, Lordship,
Which
I have
one?
not received the copy of the reply. Has not been served upon me. This is opposition.
For a long time it was up, my lord. Every time
Whom
they
did you
convey.
serve?
Anyway, we need not, we need.
See,
Yes.
I have a chamber. He knows. He is serving almost. But yeah, it's a big company, Your Lordship. Nobody knows how he will serve.
Serve the copy.
Serve a copy.
Yes, what is the matter about?
Very painful matter, short now because of the circumstances. A requirement of supply of sulfuric acid, my lord, to the respondent authorities. An e-tender was made. I am the only person who manufactures sulfuric acid, the petitioner. So I was most eligible for this purpose. However, in the tender process, my lord, I did not succeed. At that point of time, I had challenged the tender process and unsuccessfully so. However, my lord, an honorable single judge of this honorable court, my lord, had passed this order at 111, annexure P3. Affidavits of service filed in court are taken on record. None appears in behalf of the private respondents. The matter relates to tender being draft such and such dated 27 March 24. Petitioners participated in the tender process and emerged as the L4 bidder. According to the petitioner, L1, L2 and L3 bidders do not possess the eligibility criteria to participate in the tender process. Representations are made before the respondent authority. None has been answered properly. Learned counsel representing the respondent authority submits upon instruction that L1 bidder possesses the eligibility criteria for participating in the tender process. 2 and 3 were ex facie out, but L1 possesses the criteria. Let the documents relating to authorization of the L1 bidder be handed over to the learned advocate representing the petitioners in course of the day. Let WBPDCL also serve a copy of the work order, if any, issued in favor of Sudha Chemicals to the petitioner. List the matter the next day. Now, my lord, the next day, my lord, the matter was taken up for consideration, and my lord, the same was dismissed. That's 128, annexure P5. Now, my lord, the second paragraph. Primary contention of the petition is that L1 bidder did not fulfill the minimum eligibility criteria to participate in the tender process. Documents relied upon by the L1 bidder at the time of submission of the bid are not consistent with the terms and conditions of the NIT. According to the petitioners, the L1 bidder has not been able to produce a proper authorization letter from the manufacturer of the goods that is to be supplied. The rate quoted by the L1 bidder does not appear to be a fixed one, as the manufacturing company from where the L1 bidder will purchase the goods has not vouched upon the pricing. It has been submitted that the petitioners are the manufacturers of sulfuric acid and is in the best position to supply the acid at a competitive rate throughout the entire contract period. Learned advocate representing the West Bengal Power Development Corporation Limited submits upon instruction that the authority has confirmed that the L1 bidder will be in a position to supply the goods for the entire contract period at the rate mentioned in the notice inviting tender. On being satisfied with the eligibility, the contract has been issued to the L1 bidder. Reliance has been placed on the judgment of the Honorable Supreme Court in Tata Motors. Court should not already interfere. Therefore, my lord, paragraph 7. Upon hearing the parties and upon perusal of the documents, no glaring defect and or inconsistency has come to the notice of this court requiring interference. Paragraph 10. Writ petition fails. The tender issuing authority shall, however, ensure that the L1 bidder is in a position to supply the required goods in terms of the notice inviting tender for the entire contract period. Now, what was the difficulty with L1? Kindly, my lord, see page 79 to 79 of my lord's brief. This was one of the terms of the tender.
Lordship, this is hit by doctrine of merger. Because the appeal also, yes, they preferred appeal.
My lord, simultaneous dealing will cause a bit of problem. I will make it as short as possible.
No. Sorry.
Take your seat. Yes.
At least he
I
and
will
I
come
have
to
not
you.
merged yet.
I will come to you.
We have not merged, so. Now, my lord, page 70, page 79.
If you will merge, then it will be difficult to
for him to demerge. But no companies that can ever cause that to happen.
Then this court will also problem because you cannot enter into the
Yes,
room.
then my lord, only thing will be virtual. That's why technology evolved in 2020, my lord. Page 79. Please see the scope of work, which was part of the eligibility criteria, technical details, paragraph 2. Sulfuric acid consignments have to be delivered at the sites Shagordihi Thermal Power Plant, Kolaghat Thermal Power Station and Shantaldi Thermal Power Station of WBPDCL from the manufacturing units. Transportation arrangement will be fully under the scope of supplier. The consignment of sulfuric acid shall be delivered at respective thermal power plant by suppliers' tankers with arrangement of containers, and these shall be uploaded within the power plant at the area identified by WBPDCL site for this purpose. Now important, in case of the manufacturer's authorized vendor, supply of material should be from authorizing manufacturer's unit oblique stock point only, documentary evidence to be submitted along with such consignment, which means that if the manufacturer himself supplies, then there is no issue. However, if the successful bidder is the authorized vendor, he has to give documents. Now, therefore, my lord, page 129, the caveat issued by the Honorable First Court, the tender issuing authority shall, however, ensure that the L1 bidder is in a position to supply the required goods in terms of the NIT for the entire contract period. This was carried in appeal by us and unsuccessfully, and that resulted in the appeal being dismissed. That's at page 136. We find no grounds to interfere with the order passed by the learned writ court. To answer my learned friend's question on merger, the order impugned has not been interfered with in appeal. The result being that the order impugned is there in full force, including whatever direction was there. Now, my lord, what do we find now? Please have a look, my lord, at our. While on this brief, my lord, the last document which my lord will see from here is, my lord, please see, my lord, 127 of my lord's brief. This is the document, my lord, which they have furnished to the West Bengal Power Development Corporation Limited. Reference to the above, we wish to inform you that we hereby authorized Sudha Chemicals Company, Gwalior MP, who is our authorized dealer, so successful guy, to participate for the same on our behalf. You are requested to please provide your full cooperation to them. We assure that in case order is being awarded to Messrs. Sudha Chemical Company, Gwalior, they will make the supplies from any of our Khaitan Chemicals and Fertilizers Limited, Nimrani, Madhya Pradesh, Jhansi, UP, or Rajnandgaon, Chhattisgarh plants, as we sell product X Works, Nimrani, MP, Jhansi, UP, and Malwan, UP, and Rajnandgaon, Chhattisgarh basis, and transportation and insurance in the scope of Messrs. Sudha Chemicals Company, Gwalior, MP. So this is the letter of authorization that's given, that from that point it will be taken and that it will be discharged. Now the work order is awarded. I am out. I don't challenge the order of the division bench before a higher forum. I am out. Now I find that in violation of these terms, despite my being the only person who was the manufacturer and therefore should have qualified, now these terms have been violated. Please have a look at page 147 now of the writ petition. These are the OA bills, my lord, which we have got, my lord, from the public domain. These OA bills show, my lord, the transfer. Now, my lord, the goods being given. Now, my lord, kindly see annexure P8 at page 147.
Yes.
This is generated by 20th of February 2025. Kunal Chemicals is the generator. Now, GST in supplier is given Kunal Chemicals. Place of dispatch Haldia. place of delivery is Santaldi, West Bengal, and this is the way bill which covers a dispatch pertaining to HSN code 28070010 sulfuric acid. My lord has seen HSN code is last but 2 lines from the bottom, that row.
Yes, HSN code.
Yes. Value of goods is 254030. Transaction type, combination of 2 and 3. So this way bill shows, according to me, inter alia the following. Number 1, the person who has supplied is not Khaitan Chemicals, not the authorized manufacturer who had said that I am authorizing him. It's one Kunal Chemicals. And the Kunal Chemicals is not Khaitan, and Haldia, from where the dispatch is made. Please see dispatch. My lord has seen GST of supplier is Kunal Chemicals.
Correct.
Place of dispatch is Haldia. Correct. But my lord looks at the last document I had shown in the writ petition, the previous document. Their factories are not there in Haldia at all. So they are taking it from other place. Other place, other person. Please have a look at that letter again.
127.
127. Please have a look at 127.
You are requested to authorize the dealer participant in same.
So they sell from where? They make their supplies from Khaitan Chemicals and Fertilizers, Nimrani, Madhya Pradesh, Jhansi, Uttar Pradesh, Rajnandgaon, Chhattisgarh, and we sell the products X Works from Nimrani, Jhansi, Malwan, Uttar Pradesh, Rajnandgaon, Chhattisgarh basis, and transportation and insurance is in the scope of Sudha. Sudha will bring it from there.
You are
Now,
requested to provide full cooperation to them, ensure in case of being awarded to the company Gwalior MP, they will make the supplies from any of our Khaitan Chemicals Fertilizer Limited, that is the Nirman MP, Jhansi, Rajgaon plants. We sell the products to the Malwar and yes.
so these are the places where Khaitan manufactures, and that is the place from which Sudha will bring. Transportation is Sudha's job. Sudha is the highest, Sudha is the L1. Sudha has won on the basis of this undertaking, which is a pre-bid requirement or bid requirement.
Correct.
Now, after doing this, what Sudha is doing is what I have shown you, Lordship Lord, the last two, the way bills at 147 and 148.
Correct.
Sudha, for instance, in 147, has not been taking it from Khaitan, has not been taking it from any of the 5 named places of Chhattisgarh,
Nirmani,
etc. My lord will see they are not there. Place of dispatch is Haldia, West Bengal. Place of delivery is Santaldi, that's the project. Place of dispatch is Haldia. And the supplier is Kunal Chemicals. Kunal is not Khaitan. This is one. Please see the next one, 148. Once again, another supply. It is 18th of February 2025, 9:30 p.m. E-way bill. Again, GST now supplied is Kunal Chemicals. Place of dispatch is Haldia. And it's coming to place of delivery, Midnapur, Kolaghat, which is one of the plants. There's no difficulty with the place of delivery. They have to receive it at the place of delivery. Where the shoe pinches for me is, from whom are they taking and at which place are they taking? None of these two tally. So in effect, what has happened is, in a concerted way, as I had said in my earlier writ petition, there has been a fraud on the tender for the purpose of getting this person through. How? Despite not having the qualification of being a manufacturer, and despite therefore not having the exclusive coverage of the vendor, authorized manufacturer, to supply the goods from points A, B, C, D, E to point Z. He has held the same out by this bid document, and on the basis of that procured the contract. Now, the writ court, while it did not interfere, sounded a caveat and directed the department that the supply should be in accordance with the terms of the tender. That means if it is not in terms of the tender, it is contrary to the direction of the writ court. Now, my lord, when we have given this, in their affidavit in opposition, my lord, they have a very brilliant stand. Please have a look at Please see below 3A. I'll not make your lordship not go through the entirety. Please see it for the lack of information, not for the information contained in them. 3A.
3A.
3 small a at running page 3. Opposition AO by R1.
Page 4.
AO by R1. Running page 3.
Yes, 3A.
Yes, 3A. Please have a look. West Bengal Power Development Corporation Limited had awarded contract to Sudha Chemical Company on 26/12/2024. As per the notice inviting e-tender, duration of the contract is for a year. This has been clearly stated in clause 14 of section C. Thus, the contract between West Bengal Power Development Corporate Company and so shall end within December 2025. Photocopy annexed. Now, my lord, please have a look at the subsequent parts, my lord, where they have dealt with.
What is your prayer?
My prayer, my lord, was setting aside everything. Now this becomes irrelevant.
Infructuous.
That has gone. But cause of action hasn't become infructuous. I would request your lordship under Order 7, Rule 7, if your lordship is satisfied that I've been able to prove my cause of action, then under Order 7, Rule 7, my lord, responsibility should be taken, my lord, by the authorities to identify the persons concerned and take action, because otherwise this happens the next time also. Today, all these were lease pendants events. I am not suggesting that by lease pendants the contract has to be struck down. It's too far of a cry. If one is, the classical view is whatever happens by lease pendants, if in the end the court finds substance, then that is undone and the successful plaintiff is put in the position as he were, without those intervening things happening. That's the classical theory.
No, tender time is over.
Now, second is he has supplied. So I can't say that today, therefore, undo his supplies. They've already been used. Third is, when your lordship modifies it under Order 7, Rule 7, including the omnibus prayers, there was a direction from court that this should be done in terms of the tender. I have brought materials on record to show that this was not done in terms of the tender, and this is a manner in which persons who are not eligible are brought into the fray. Therefore, if your lordships are satisfied with the cause of action which I have sought to prove here, if your lordships are so pleased to issue an appropriate direction that this thing be looked into by the appropriate authority of the WBPDCL and a report filed fixing responsibility, the same be filed in court, then, my lord, my prayers will be answered. Otherwise, they will go, if they go scot-free only on the basis that this has now become infructuous in terms of actual remedy to me, then, my lord, this will happen over and over again. So, my lord, only on that.
The better thing that you go to the civil court and file a damage.
For damages. I had told him that.
That will be better. What is your interest now? Because your interest is.
I can understand. There were two things. The first thing I said, now that this has gone, if anything wrong has been done to me, then I'm entitled to be compensated in terms of damages. Reed court can't award damages. তাহলে ওটা লিবার্টি নিয়ে চলে যাবে।
That will be better.
ওর কন্ডাক্ট নিয়ে যদি এখন যদি কিছু বলেন জজ সাহেব, তাহলে তো ওটার মধ্যে ঢোকা হয়ে যাবে। সুটের মধ্যে কি করে ঢুকবে?
May I just submit?
My prayers are this. My instructions are slightly, let us say they are the client's instructions, that in the event my lord is pleased that this cause of action which has been made here is prima facie is satisfiable on affidavits, if I can show that, then my lords would be pleased, my lord, to make appropriate orders of censure and an order directing that these persons be pulled up. This is what the modified prayer is. I understand damages should be the best case scenario, but only problem.
See, that is also to be proved.
Yes, of course. Nothing happens automatically. Damages has to be proved in a suit full scale trial. But then here at this stage, my lords,
hands are tied.
And yes.
Hands are tied.
Contract, yes.
Under the 226.
Do I have brought MP power which says now my lords can go into, but this is neither here nor there. So, the one MP power will be made by 3 anti-MP power and again 1 MP power. So, open it. Kindly, in view of this, that the tenure has expired, my lord, kindly, my lord, permit us to agitate this in a suit, in an appropriate civil proceeding. We have appropriate forum. In accordance with law. Section 14, I can't seek benefit before your lordship. I have to seek it before
Not necessary.
Automatically this comes.
The section 40 is not necessary because
These
December
will
25.
be within 3 years, yes.
Lordship, they can always approach the civil court. They do not need any order. And secondly, your Lordship, I am not circumventing the points, your Lordship. They have raised a substantive point. 147 and 148, the e-way bill.
Go into this anymore after.
No. E-way bill. The e-way bill
That
does
he is
not.
appearing, that to authority.
Why did you not say anything when the petition? But he was losing. The answer is, but he was losing. He would have lost more, had you said.
No. Here, your Lordship, this 147 and 148, the e-way bill is not even a prima facie evidence that the goods have been sent.
That's why I am not. That's why the court is not good. That's why
secondly,
Mr. Banerjee is sufficient enough to
it has become
read the mind of the court.
And secondly, your Lordship, they are saying that they are harping on just 1 minute time, Lordship. They are harping on an order that has been challenged before the division bench, and an extensive order has been passed. So that order ceases to have any effect. Ceases to have any effect.
You done your work. You got your tender work executed. And as per your affidavit, December 2025 is over. So nothing remains in this.
Nothing remains in this matter.
The petitioner has filed the present application on the ground that the private respondent is a party here.
Yes, all the
private respondent number 3.
Yes.
3. Respondent, not private. Respondent number 3 has violated the terms and conditions of the tender as well as the order passed by this court while supplying the sulfuric acid to the WBPDCL.
Lordship, they are not privy to the contract.
That's the submission I am recording. Learned counsel for the petitioner has relied upon counsel for the petitioner submit that the initial stage of the tender process, the petitioner has filed the writ application being WP 1417 of 2025, in which though the writ petition was dismissed, but this court has held that the L1 bidder shall ensure that the supply the required goods should be supplied in terms of the notice inviting tender for the entire contract period. Learned counsel for the petition submitted the order passed by this court was duly affirmed by the appellate court in an appeal preferred by the petitioner. In spite of the order of the High Court, the petitioner has relied upon 2 e-way bill appearing in page 147 and 148 and submit that the petitioner has not the private respondent has not supplied the materials in terms of the tender document as directed by this court. The respondents have filed the affidavit in opposition. In the affidavit in opposition, it is categorically mentioned that the contract between the WBPDCL and the respondent number 5 has ended. Already ended. Not extended.
Not at all extended.
Has ended in the month of December 2025, and thus there is nothing remains in the present application. Consider the submission made by the counsel for the parties. This court finds that the main grievance of the petitioner that the respondent on the basis of the submission made by the counsel for the respondent on the previous round of litigation, this court has dismissed the writ application with the rider that the private the L1 bidder shall supply the required goods in terms of the notice inviting tender for the entire period, but the petitioner is having sufficient evidence that the private respondent has not supplied the materials in terms of the tender in terms and conditions of the tender document. This court find that the tender period is completed, and no relief can be granted in the present writ application. Accordingly, the writ application is dismissed, but however, the writ petitioner is not prevent for taking appropriate step before the appropriate court of law for claiming damage.
Lordship, another point, Your Lordship. No.
There's a Competition Commission of India also.
क्या बोला? However, the petitioner is however, the dismissal of the writ petition will not prevent the petitioner for taking appropriate step before the appropriate court or before the any appropriate authority.
Lordship, another point, Your Lordship. Just there, the other forums will not be not take any just the substantive matter, Your Lordship. Other forum will not take any into consideration any observation, Your Lordship.
That's right. This court has not gone into the merit of the case. The authority of the court where the petition will approach are free to take appropriate decision in accordance.
Merit of the case, yes.
That's all.
Yes.
Your Lordship, yes.
I might ask him again. Maybe 10% more is even.
Yes, next.
I had a leader while I was in the corporation panel. I had a leader. I won't take his name. He used to oppose everything. So we oppose adjournment, oppose everything. So one day, what happened is petitioner came and said, I don't think that I have any case. I've gone and found that the calculation on the basis of which I have run is wrong. May I oppose?
Yes, next. 55.
I beg to appear on behalf of the petitioners. My lord, I'm praying for not this week, my lord. We are yet to receive any kind of instruction.
Not this week. Okay.
Grateful, man.
Okay, original side matter. 3 o'clock at original side. Okay, call the next matter, then we'll see to that.
Lordship, led by Senior Mr. Sabyasachi Chatterjee, he is online.
He is online? Nobody is there.
Praying for not today. Praying for then not today, sir.
Not today?
Because I have no instruction to proceed with the matter.
Okay. Original side.
Very short. I've been waiting for this matter for.
Which one?
Item 57.
57. Call the 57.
My lord, I am appearing for the respondent, number 224.
Well, this matter, my lord, on the last time when the matter was taken up, my lord, the respondents were not there. I was directed to serve a copy.
My lord, I am appearing for the respondent number 224, my lord. Online.
Well, this is a very short matter. Well, it may
My
please
lord, before starting the matter, my lord, I just want to highlight one point, my lord, whether they have the locus standi to file this writ.
I understand. I have to address that point. But I'll satisfy your lordship on the point of locus.
I'm for the
My lord, I was library in charge who got superannuated in the year 2021. Nothing to do with the service matter, my lord. Nothing to do with the service matter. I've given the background. My lord, in 2019, a recruitment drive was carried out at Indian Association for Cultivation of Science, a research organization under the Ministry of Department of Science and Technology, Government of India. But by virtue of my experience in the administrative side as well, I was appointed as in charge for conducting the examination process. My lord, the entire recruitment drive was carried out at breakneck speed. My lord, the timing of the recruitment drive was, my lord, just before the second phase of pandemic. 2,000 applicants, my lord, have applied, 1,000 appeared. My lord, out of that, my lord, the entire examination process was archaic written examination. My lord, nowadays, as per the prevailing practice, my lord, we have to go for MCQ. My lord, that apart, the answer sheets were not signed by the invigilator in view of the COVID pandemic situation. My lord, all these things, my lord, have given an opportunity, my lord, to the unscrupulous elements, my lord, who was supporting some of the departmental candidate, contractual candidates, some of the wards and relatives of the employees. My lord, all these things have surrounded this examination. But in the meantime, I superannuated. My lord, while the examination process was complete, I, being in charge of the examination process, has put in this sealed cover, filed my report, and the entire answer sheet scripts were kept in a strong room. But subsequent,
For your superannuation now submitted the
I have submitted. It was kept in a strong room. My lord, under the seal of and lock. My lord, I acquire certain knowledge from my acquaintances. My lord, after my determination of after retirement from service, that the answer scripts were tempered. Well, what I did, I have written to the authorities that look, I have come to
How you come to the tempering?
from the employees. Well, what I'm asking for, I have alleged, I've got acquired this information of tampering, and even I'm a member, life member at IA Indian Association for Cultivation of Science. So even after cessation of my employment, I continue to be a life member of the Indian Association of Cultivation of Sciences, which I have pleaded. But in my capacity as a stakeholder in the organization, I have sought for investigation. Well, after this, the director has not acted upon my letter. I have written to the Department of Science and Technology. Well, now, in turn, the Department of Science and Technology has written to the director, well, requesting to deal with my application. Well, what I'm asking for before Lordships today, that my grievance should be considered. Well, since an equity has been created in my favor, but even assume that I don't have a locus. The moment a letter was issued in my favor, from the Department of Science and Technology, advising the director to deal with it, the right has accrued in my favor. I'm asking for consideration of that representation. Kindly takes the document which I'm referring to.
Okay, come tomorrow.
Can it be upgraded?
Tomorrow is the number one matter. Will be there under the adjourn motion. The learned counsel for the petition has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter remain in the list at the top under the heading adjourn motion.
So grateful, my loss.
Grateful.
You need a number there. Appeal for it.
Tomorrow kori din top, adjourn motion.
Your Lordship, may I have your kind leave to mention item number 48 and 51, Your Lordship. The interim order is expiring tomorrow, Your Lordship. I'm mentioning upon notice, Your Lordship. The interim order is on the last page.
Tomorrow to be mentioned
Grateful, Your Lordship.
for extension of interim order.
With regard to item number 139, the Dallas Athletic Club matter, which was last Friday I had mentioned for extension. It has been it has been settled. A memorandum of understanding has been entered upon between the executed. My lord, a copy is there. If my lord.
Item number?
Item number 139 of the today's list.
139. Rajat Kumar.
Rajat Kumar Singh.
So, infractors.
Yeah, the suit has become infractious, my lord. It has been settled out of court, my lord. A memorandum of understanding.
Can be disposed of?
Can be disposed of. The suit.
139. Learned counsel for the petitioner. Both the learned counsel for the respective parties are present. Learned counsel for the petition submitted. The matter have been settled between the parties by entering into a memorandum of understanding. Dated 9th of January 2026. In view of the settlement between the parties, counsel for the petition submitted the return the review application, but the CS number 173 of 2023 has become infractious. Heard the learned counsel for the parties peruse the memorandum of settlement. CS 173 of 2023 is dismissed as infractious.
As non-proceed.
As infractious. Let the memorandum of understanding be kept with the record. Accordingly, connected application also disposed of.
Connected applications. There are 5 applications.
Where?
The applications, the connected GA1, GA2.
Connected application also disposed of.
And another matter, my lord, I read with regard to item number 102 of the today's list, my lord. That is relating to a passport, my lord. If the criminal case is pending, if my lord.
Go to the criminal court, get a permission from the criminal court.
The stay has been granted by the High Court, my lord.
What?
The stay of the proceedings. It's a developer who had the person who has initiated.
So what do you want now?
My lord, if this matter be taken up any day, my lord, the passport would be renewed.
That is a big problem before this court.
Any day. It would take 5 to 10 minutes. 102, my lord, any day.
Yes, next.
May I permitted to mention a matter, my lord? In today's item number 115, my lord. My lord, can it be upgraded, my lord? This is a new motion, my lord.
What is the urgency?
My lord, the urgency is that the bank has already taken possession of my residential flat.
Here?
The bank has already taken possession of my residential flat, my lord. So that is the urgency, my lord.
Doesn't go to the surface. What this court will do? Under the surface.
No, surface.
Under the surface, how
this matter has been filed before your law.
you might be filed, but it is no under the surface.
But I think, I'm not the advocate on record, my lord. So I have
take instruction. I will take the file. If it is surface, I will release the matter. Take instruction.
May I hand over the list?
Come with the instruction whether it is surface or not. Notice under surface and taken possession under surface. This court is not having the determination. Yes, call the list.
There are connected also the trial court before the civil court of matter is also pending, my lord.
I cannot. You mentioned there.
Put up a petition may be filed, joint put up petition
Yes.
may be filed.
The Usi mein likho, madam. It is submitted by the Learned Council for the parties that a civil suit is also pending before the Learned Court before the City Civil Court. Police the petitioners of liberty to take appropriate step before the court for withdrawal of the suit.
I'm ready. Grateful.
May it please, my lord. My lord, this is the suit for damages for defamation.
Yes.
On the occasion, my learned friend has written a letter to my client as well as to the advocates, my lord, apologizing. We'll take instructions. Of course, the injunction has to remain, the decree. If my lord permits us to come back after 2 weeks or 3 weeks, my lord, we'll come with a suggested order maybe. Because we don't want to, we are not advising them to withdraw the suit unconditionally, of course. This 20 years is gone on the suit. But we'll try.
In this matter, I am for the dependent of 1 and 2, my lord.
Yes.
Yes.
My lord, we'll keep it after the 26th.
You have the instruction?
No, they're considering it.
My lord, we have already sent a letter apologizing the situation, my lord. And since my learned friend is seeking time to take instruction,
Okay, let them take instruction. I am fixing after 2 weeks.
My lord.
The Learned Council for the defendant, respondent number 1 and defendant number 1 and 2, has filed their undertaking of apology after serving the copy to the Learned Council for the printing. Learned Council for the printing press for 2 weeks time to take instruction.
Yes.
According
I'm
to
grateful, your lords.
let the undertaking of apology be kept with the record. List the matter on 29th?
Yes.
29th of January 2026 under the same heading.
Great.
Good. Can it be on 28th, my lord?
Then come on 30th.
As to be mentioned, let it come.
Okay, 28th.
As to be mentioned.
28th. I'm grateful, yours. I'm grateful, yours.
Yes, next.
What
instruction?
It's a probate. My lord, we would want to do it before your lordship, my lord. We would want to do it before your lordship, my lord.
Why? Go to the probate.
My lord, probate proceeding, my
Testamental
lord.
court.
Probate proceeding, my lord, ideal situation, my lord, before your lordship. Not otherwise, probate proceeding, yes, my lord. My lord, your lordship will see the demeanor and everything of the witnesses. I have 2 witnesses only, my lord, after this. And then, my lord.
But there is no time.
My lord, probate proceeding, my lord, it is important, your lordship.
What?
My client also wants to pursue the witness action before your lordship. Not through the
My lord, we are together making the same prayer, my lord. But only this will be the only prayer we are making it together, my lord.
come with the similar prayer in the merit of the matter.
Lord, your lordship will grant the probate, my lord.
Probate by witness is not going there.
My lord, probate matters, it's better, my lord. Your lordship sees, my lord, what is happening also. Well, especially in this case, my lord, whether one of the, my lord, here it's one of
What
the
is the
daughters.
stage? Evidence?
Evidence stage. One of the daughters, my lord, my learned friend, is one of the daughters of the deceased. She is contesting the probate. Other 5 children are not contesting.
Judges briefing kept that. Kab hoga? Evidence. How many witnesses you are having?
I have 2 more witnesses.
You will have evidence.
The testing witness is already done. I have 1 chartered accountant and the propounder,
Petitioner.
the petitioner.
So 2 witnesses.
2 witnesses.
And how many witnesses you are having?
We are not sure whether we
2nd March.
Your lordship will hold, my lord, that both parties are insisting on
March evidence.
March is fine. We'll come back. I'll try and do my cross, my chief on the same day, and they can start the cross also on the same day.
It is
My chief
submitted
will
by
be.
the Learned Counsel for the respective parties. The case is at the stage of witness action on the plaintiff side. Plaintiff has already examined 1 witness and plaintiff intend to examine further 2 witnesses. In view of the submission made by the counsel for the parties, let the matter appear on 3rd or 2nd March or 2nd and 9th March 2026 at 3:30.
2nd March, I can do my chief. They can do the cross on the next.
2nd March and 9th March 2026 for witness X at 3:30 p.m. Yes, item number 3.
My lord, I appear for the petitioner, your lordship. My lord, she said that she has some personal difficulties, some bereavement in her family. Therefore, she was asking adjournment. If my lord kindly fixes the matter, this comes under the heading court applications, my lord, only on Tuesdays and Thursdays. If my lord kindly fixes the matter on Tuesday, my lord, June 20th, it's an important matter. It will take some time. This is a posh matter, your lordship. Posh matter, my lord. So, my lord, I heard it in 2 occasions, my lord. And
as per the prayer made by the counsel for the respondents, the case is adjourned. Let the matter appear. Kaun sa date hoga?
20th January, my lord. 20.
20 January at 3 p.m.
Deeply obliged, my lord.
Yes.
Yes, sir. Lordship. So this is a very simple, non-complex matter. This is just behind we have a rent control, and I have some dues which has to be collected, and they are not want to disburse those things, and they've been for last carrying on for years. So that's why I was forced to come to the court and to.
Who are you?
So I'm the landlord of the building.
You are the landlord.
Yes.
And
and there are a lot of corruptions, and there are a lot of you'll see on page.
What is the writ petition? Praying for the
The rent control which has to be collected, what they have deposited, the tenants have deposited.
whom the rent is to be collected.
It has to be collected from the rent control office at ground floor in Kiran Shankar Rai.
No, you are the owner of the property.
Yes.
Correct. You are the Sandeep Krishna
Right, sir.
Rohtagi.
I am person.
And founder Asia Safety, who is this?
So I am also the founder of the Twitter account.
Founder of that.
Right.
What is this? This is any business? What is
No, this is I work for road safety and false cases and all that.
safety and false cases? So, to whom you let out the premises?
This is one person, Rajesh Shah, whose dues are there from 2015, and today is 2025, 26.
Who has ascertained with regard to the dues?
So you'll see an extra one, please, Lordship.
Yes.
So this is one due which is around about 1100, which has to be paid by them. I've been going like anything, and they're not want to release. And they remove the papers. They put it down in their files, and it is so dusty.
Tenant Sailesh Khatri.
Yes, he deposited one, and then now he's left the building.
So he deposited
You're
before
right.
the land controller.
Yes, Lordship.
And
there's the next one, which is they are not issuing the receipt from 2015, which he's the office of the rent controller. They have issued it
So
from
you
20.
So you mean to say all the tenants have deposited the rent
No,
before the rent controller?
no, these two did not. They had deposited. Others are paying. Others are paying directly to me. And this is the receipt.
So with regard to the Sailesh Khatri, he has deposited 1100 rupees
Right.
in 2017.
Right.
So
And
that is still pending before the rent
yes,
controller.
they don't want to just once.
And
They're not.
with regard
And
to
the next one is Rajesh Shaw, sir.
Rajesh Sahu from
The
22nd.
due, so Lordship, the due is from 2015 March, but they are not issuing that. They have issued from 22 the receipt.
Who is appearing for the rent controller here?
So I've sent them, and they've received it. So
why you're not? Have you filed an application before the rent controller for release of
So
the
I want
settlement?
to deposit this certificate. What do you call it? Affidavit of service.
No, so you have filed any application?
Oh yes, many times. And now I have multiple.
Where is the application before the rent controller for release of that amount which has been deposited by your tenants?
So this is the receipt, sir. Annexure 2, sir.
No.
This is the receipt when I give a
That's
letter.
correct. Where is the application filed by you before the rent controller for release of that amount in your favor?
The thing is that you have to just give them the details of the agreement, the receipt, and they issue this kind of thing. And it has been issued in the name of my father, Dr. V.S. Rodgi. And now I am the inheritor, so I have to get this payment.
That's correct. That's correct.
Why?
That's correct, sir. I totally agree with you.
Right.
One thing is pending before one authority.
Right, sir.
So you have to approach before the authority for take back.
Sir,
Where is your application before the rent controller, sir? These are the amount you have certified that is to be released.
Sir,
you are appearing.
Sir,
Is it Sandeep Krishna?
yes, sir.
Yes, for the brief,
You are appearing for whom?
for the state of West Bengal.
State of West Bengal. Current Commissioner of Police, rent controller, they are appearing.
From statement, I have already asked for the instruction in this matter to make the affidavit.
Affidavit of service here.
Yes, ma'am.
So you only take instruction from the rent controller. Why the register presidency small causes court? Why you made the register presidency small causes court as a party here?
So they are all in the. Goes through. It goes through them, sir. It's all.
So you see, because you have issued the certificate, correct? The amount is deposited by the tenant Rajesh Shaw. So if the amount is deposited, then it has to be returned to the owner.
Yes.
If it is not dispute with regard, there is no dispute with regard to the ownership.
No dispute at all.
So you take instruction when?
So it's around about 50,000-60,000. It will be very useful to me, sir.
You take and come with an affidavit, a report as an affidavit. I am fixing a week after. So that will be better. That's why affidavit report by way of an affidavit.
Much honor.
The counsel for the respondent is directed to file a report by way of an affidavit within a week after serving the copy to the petitioner. Let the matter appear on
Within 10 days, instead of a week, it's 10 days.
within 10 days.
So it's already 10 years, sir. It's now what will 10 days do?
Exactly. So what will turn out?
Let the matter appear on 28th of January.
Much honor.
Affidavit of service filed by the petitioner be kept with the record.
Good.
5 and 7, if your lordship permits them to be taken up together, they arise out of the same issue primarily.
5 and 7.
5 and 7.
Which are the respondents?
The Simon Singh is appearing on behalf of the respondent bank, my lord. Please engage another code. I prefer for password.
Let me understand what is the case
Right.
about.
My lord, there are two writ petitions before your lordship. One filed by the company by the name of Western Oars. That's item 5. 7 is by Vikas Bansal, Ramkishore Bansal, and Satpal Bansal. Well, before I take your lordship through the documents, let me just tell your lordship the brief background to this petition. Well, there are two companies. The two companies are the respondents number 3 and 4. They are Ishpat Damodar Private Limited and Sonic Thermal. So Damodar and Sonic, they take loan from the two banks, Indian Bank, the respondent number 2 over here. Now, against that, there are certain, as guarantors, these three individuals, as also the company, Western Oars, they provide security.
So you are the guarantor.
Yes, we are the guarantors. Some of them are guarantors without any collateral. Some have provided collateral also against such guarantee. Now, thereafter, in course thereof, the company, while this was going on, the company was sold to one person by the name of Onup Maji. But since the entire amount did not come, the management was transferred, but the shareholding still stood in the erstwhile old name. Now, in course thereof, because Onup Maji was an FIR was started against Onup Maji and others in respect of this coal scam, which took place in this state of West Bengal. CBI had initiated the case under Section 420 and various other provisions. As a corresponding flow down, the ED had also registered an ECIR. In course of the ECIR and the corresponding proceedings under Section 17 and others, the ED had initiated proceedings for interim attachment of the plant machinery and other assets, stocks and assets of the two companies, that is respondent number 3 and 4, Damodar and Sonic Thermal. Well, in the meantime, and this was confirmed by the tribunal also, that only the assets of these two companies are being attached. We have annexed the order also. Now, in the meantime, thereafter, all the dues of the banks were duly paid off. These being nationalized banks, they are guided by the RBI guidelines, in fact, as others also. Now, since they gave us the clearance certificate that there is zero dues in respect of all credit facilities which have been obtained by the respondent numbers 3 and 4, these petitioners, they approached the bank for releasing them from the onerous duty of being a guarantor and for release of the properties which were given as collateral against such personal guarantees and corporate guarantees. Now, at that stage, the Indian Bank wrote to us that we have written already to the ED, please wait for 30 days and after that we will take necessary steps. 30 days had lapsed long back. And thereafter, despite writing on several occasions, the bank has not acted in terms of the RBI guideline, which we have also annexed to the petition, first petition at page 492, that if there is a zero due, they must return it. And neither of the petitioners before your lordship are either there in the FIR or the ECIR. They are not accused persons. And these happen to be personal properties which are not subject to any attachment proceedings by the ED. There is nothing on record. Now, therefore, we have come before your lordship asking for a direction upon
You have submitted any reply?
Well,
State
no,
Bank
this is the
given
first time.
No. Statement.
No. They have only at the first instance they had said that we have written to ED. Please wait for 30 days. We'll get back with the response. Thereafter, there has been no response despite us writing on several occasions.
Okay. Yes. Simple thing. You come with the report. Why you have kept the collateral security as and why you're not releasing? If there is no case is pending, they are not the party in the case. Yes, you understand what the submission has been made by the London Council. Inform your senior when you file the report. Within 2 weeks, report by an affidavit, submit the after submission, giving the copy to the London Council for the petitioner. I am fixing after 2 weeks.
Very deep.
This could find that
2 weeks
a report is required to be filed by the Indian bank, mild corporate bank.
Well, State Bank and Indian Bank, the respondent number 1 and 2.
Required to be filed by the respondent number 1 and 2. Accordingly, the respondent number 1 and 2 are directed to file the report by way of an affidavit within a period of 2 weeks after serving the copy to the London Council for the petitioner. Police that the petitioner is also in liberty to take exception to the report, if any, within a week thereafter. This is the matter on 10th of February 2026.
I'm deep. Deep. But it is 3 সময় নেন. Well, it may be made
5 and 7.
Well, can it be at 3 o'clock, subject to your lordships?
I don't find you will.
Well, otherwise it goes down in the list. That's why. Otherwise, I would not. Your lordship can understand we are being unnecessarily. Can it be at 3 o'clock?
I can understand, but my diary.
On behalf of the respondent.
So you file the report within 2 weeks?
I said. But the fact remains, I will disclose it.
That already disclosed, that will be better.
That's it.
कब होगा देखो कुछ है डेट पर.
Well, it may be at 3 o'clock, subject
3
to your.
o'clock. हाँ? कब में कर?
I'm deeply obliged. Deep.
It's a lordship.
Next. 8.
Hijack করলে ম্যাটারটা তো
Item number 6.
6 মানে the hijack matter মানে with Mr. Ganguly মানে this মানে petition মানে the subject matter মানে is a fundamental right মানে which I now see is right to shut shop. Very interesting. But I found that that's also now considered as a right by the Honorable Supreme Court with regard to saying right to shut shop. This petition J. Thomas Finance Private Limited.
ये कौन सा मैटर दिया?
Item number 6.
Item number 6.
WP 642. WP 642.
I am saying the prayer and thought that same prayer is making.
আপনি 7 দিয়েছেন নাকি? হ্যাঁ। My lord, what has happened, my lord?
Yes.
The petition, I'll just, my lord, since my lord, the time, I'll just give, my lord, in brief, my lord, what the matter is. Like I was saying, my lord, it's fundamental right to shut shop. My lord, J. Thomas Finance Private Limited, my lord, is an NBFC. My lord, knows in NBFC, if your capital, my lord, is above, my lord, a certain, my lord, investment, then you can be termed as an NBFC and you need a license, my lord, from the Reserve Bank of India. Now, my lord, we made an application to Reserve Bank of India saying, my lord, that we want to not be an NBFC, so you please cancel my registration, which I'm permitted to do. Because if I don't want to, my lord, carry on business at NBFC, I can do that. And I don't want to carry on business at NBFC. And prior to that, my lord, they had come out with a circular saying that to be now continue as an NBFC, you have to increase your net worth from 5 to 10 crores. So, my lord, it's really like egg and the chicken situation. So I said, I don't want to carry on. You now ask me, I'm cancelling. They, my lord, they did not do anything on that. Then they came up, my lord, with another notice to me saying that you increase your net worth, net owned fund from 5 to crore. We said, no, we have made an application prior to all this and we don't want to carry on business at NBFC. So that is how
you are the lucky enough you are inviting to do the NBFC.
I don't want to carry on because genuinely people are NBFC and they have an issue with being. I don't, but because this now company doesn't want to carry on business as NBFC. This is J. Thomas. They want to now, obviously. Now they say, no, now your net worth is still more. So then you cannot, your license can't be cancelled. That is what is under challenge here. So because what has happened, I want to go out. You increase the level first. I want to go out. You come back and say, no, you increase your limit. Then I say, no, I still want to go out. Then you say, no, sorry, you have to increase your limit. Because then only you can carry on business NBFC. And this is where we are stuck. May I just show our first, kindly see
Page 74, my lord, is just, my lord, for the records, my lord. This is originally, my lord, what we, the certificate is there. Then, my lord, page 75 is, my lord, the notification. 18 February 2025.
Yes.
This is subject, dear sir, subject achieving net own fund. Achieving net own fund requirement of 5 crore by March 31, 2025. Please refer to para 6 of Master Circular, Master Direction, Reserve Bank of India, Such, dated October 19, wherein Reserve Bank of India specified net own fund requirement for NBFC commence or carry on business. Following guide path was also provided for the existing NBFCs to achieve the NOF of 10 crore. Then current NOF 2 crores by March 31, 2025, 5 crores. By March 31, 2027, 10 crores. Then my lord, NBFC, I come, my lord, under NBFC, ICC, Investment and Credit Company. Then my lord, page 76, my lord, will find they say it has been observed from return submitted for 31/2024 was rupees 26.6, which was below 5 crore. In view of the above, you are hereby request to advise achieve minimum prescribed NOF of 5 crore by March 31, 2025. Please note that non-compliance will be very seriously and may attract supervisory action. So by March 31, I was to, my lord, increase it to, my lord, 5 crores. Now, my lord, kindly see my application. My lord, page 78. 78. What resolution?
Page?
Page, my lord, 78, my lord, is the application.
Surrendering certificate.
Yes. And this is on the basis of, my lord, the resolution. I'll just show, my lord, page 77. Kindly see, my lord, this is dated 18 March 2025, which is received by them, my lord, on 20th. Application for voluntary certificate, surrender of certificate of registration. We make this application in terms of section 46 IA 6 of Reserve Bank of India Act 1934, 29 A6 of the National Housing Bank Act to voluntarily surrender a certificate of registration. Excuse me. The requisite information stroke documents are duly filed in Annexure 1 and Annexure 2. We would like to inform you that the company has exited the business of an NBFC or HFC indicated applicable stroke fulfill the criteria for an unregistered core investment company, CIC, Caesars to Sunset, strike off mention. Hence, we hereby request you to kindly consider the request of voluntary surrender of COR and thereby cancel the COR issued to our company. We solemnly declare that the best of our knowledge and believe the information furnished to the, in this application annexed here to Sunset, complete and true, information found to be incorrect, Sunset, initial penal action. And this is on the basis of, my lord, board resolution at, my lord, page 77. Just the previous page.
Yes. Yes.
So we will find Mr. Rajkumar Sanchez placed before the meeting provisional results for period ending February 28 together with projected surplus for the year end March 31. Suggested the company was surrendered certificate of registration granted by the Reserve Bank of India, carry in the non-bank financial as the company is finding it increasing difficult to meet the statutory compliances framed by it to continue the business of non-banking financial company. Then resolve that in view of the decision board, company do hereby approve the surrender of the certificates and such. This resolution is granted for the application which I showed at page 78.
Yes.
Then 79, will find what has to be filled up, the form.
Annex.
Yes. And next, we have given item 8, serial number 8, will find 2 crore 66 is net owned fund.
Yes.
As on 31st March 2024. Then major shareholding 9 is J. Thomas. Then whether the 12 is very important, whether any NBFC, no, sorry, 13 is important, whether there are any public deposits outstanding in the books of the company.
That's why I wanted to see, because is there any other provisions?
No, no.
There's no other provision, so you have to declare. So
Yes, my lord, let me just, yes. 45(6)(a), my lord, is the only one, my lord, which has, my lord, the
you have to comply with that.
IS6, yes, my lord, for the purpose of. My lord, 13 is very important, whether there are any public deposits outstanding in the books of the company applicable for deposit taking company NBFC. If yes, no. And my lord, read this with, my lord, 5, serial number 5.
COR.
Details of your non-deposit taking company.
Okay.
Because, my lord, this is, my lord, a holding company which has, my lord, its investments by reason of its value of an investments. My lord, it's more than, my lord, the deposit. My lord, it's a group company of, my lord, J. Thomas. That is why, by reason of, my lord, provisions of the law, it became an NBFC. Where, my lord, the investments become more than, my lord, the net owned funds. So, my lord, it is really, it's not a public deposit. It's not, my lord, someone, my lord, who has taken deposit, my lord. Then, my lord, 14 is reasons for surrender this year due to non-maintenance. And this, my lord, what we say at page 79 at the bottom, very important. Reasons for surrendering the COR due to non-maintenance of the minimum net owned fund required as prescribed under clause B of subsection 1 of section 45 IE of the RBI Act 1934 within the stipulated time as per Master Direction, Reserve Bank of India, Non-Banking Financial Company, Scale-Based Regulation, Directions 2023, dated October 19, 2023. Then financial assets, my lord, sees total assets 0.85%. And financial income, gross income, 98.31. So therefore, my lord, it has to be, my lord, a NBFC. When a regulatory body enforcement agency had initiated penal action related to non-compliance, no.
Yes.
So this is, my lord, application. No, let me just finish this. Then, my lord, page 81. Board resolutions are given.
So these are the details submitted by you.
Details submitted by me.
Balance sheet.
Then, my lord, kindly come to all details, my lord, are given. And, my lord, just kindly make a note, my lord, this was done on, my lord, 20th March. Received by them on 20th March. The requirement, my lord, to increase it was, my lord, on the 31st of March 2025.
20th March 25.
2025.
Correct.
And then, my lord, at page 135. 120. Oh, my lord, no, that's not. At 121, my lord, is just, my lord, the additional documents, my lord, which had to be submitted. We have done that. Sorry, 121 also, my lord, can have a look, my lord, at 26 March 2025. This is, my lord, as on 26 March 2025.
Yes.
Then, my lord, 120. Where is the response? 135. Is there? Sorry, my lord, please come to first, my lord, page 135. 122.
Yes.
And you see, my lord, the date May 30th, 2025 on the right hand side.
Yes.
Non-compliance with the guidelines instruction issued from time to time by the bank to NBFCs. Call for explanation. In terms of 45 IE of the RBI Act, read with RBI notification dated such, minimum regulatory net owned fund, 2 crores are required to maintain continuous basis. Please find further, please refer to para 6 of Master Direction, Reserve Bank of India guideline, October 19, 2023, wherein the Reserve has specified 10 crores NOF requirement for NBFC, commence or carry on business. Following glide path was also provided for the existing NBFC to achieve the NOF of 10 crore.
Yeah.
Then, my lord, they give the same dates, 5 crore by March 31, 10 crore.
So
then 136, it has been observed from returns submitted for the quarter ending March 31, 2025 by J. Thomas was rupees 2.65 crores, which was below 5 crore. In view of the above, hereby advised to offer your comments explanation for not maintaining the required NOF position. The response must be vetted. Reply writing should reach us positive before. Then
Have they filed the reply affidavit? No.
Yes, my lord, reply affidavit also they have filed here. Then, my lord, 139, my lord, is our response.
Yes.
6 June, my lord, we reiterate that our application for voluntary surrender of certificate of registration is there.
Yes.
Then 140, my lord, we give again, my lord, the undermentioned documents.
So it is not the case that then some obligations is pending against
No,
you.
because, my lord, this is a non-deposit taking public company. NBFC, non-public deposit taking NBFC. This is, my lord, a group company, my lord, of J. Thomas. It is really, my lord, because the returns, my lord, are higher than the investment because, my lord, it's holding shares. That is why, my lord, it had to be, my lord, categorized as NBFC. Then, my lord, 160, my lord, is the rejection finally. Volume 2, sorry, my lord. Volume 2, yes.
Yes. $160.
160, my lord.
Correct. As informed by the RBI office today.
Yes, at the bottom, my lord, we'll find from Anand Kalyan Chaudhary, who, my lord, appears to be the Assistant Manager, Department of Regulation, Reserve Bank of India. And my lord, very important, my lord, kindly look at, this is very important. My lord, this is sent to us, my lord, on 4th July. At the middle, my lord, we'll find 4th July.
Yes.
And my lord, bottom we find 23rd April 2025.
Yes.
Please refer to, this is, my lord, internally, this please refer to a mail application in March 18 on the caption subject in connection inform the application volumes and CORs rejected since the company is maintaining PBC as on December 31, 2024. Principal business criteria.
Yes.
My lord, what they say is, my lord, because of the PBC, I continue to be, my lord, a NBFC.
Company is maintaining a PBC.
As on December 31, 2024. Now, my lord, by reason of, my lord, maintaining PBC, I still continue to be an NBFC. My lord knows if PBC is more, automatically I become an NBFC. Now, if I'm not, if my registration is not cancelled,
you cannot revoke.
Yes.
The PBC.
That's why I said, my lord, chicken and egg situation. I've asked for, first of all, you increase the limit from 2.5. You say, no, now you have to maintain 5 crore by March 31, 25 and 10 crores by March 31, 2027. I say, I'm surrendering. I don't want to carry on business NBFC. Now, you internally rejected on April 23rd. You don't give me the permission to say that, yes, now I'm cancelling it. You please decrease your PVC.
Yeah. Maintain.
And you come back, my lord, in May and say that, no, now you have not met the criteria.
Yes.
Now, my lord, we, my lord, gave a explanation and, my lord, we asked for, my lord, at page 212, my lord, can just have a look, my lord. That's the, sorry,
212.
212, my lord, is my letter, my lord, for, my lord.
Again, request.
My lord, demand for justice, my lord, if my lord wants, my lord, we can put it that way. And, my lord, kindly see, my lord, very important, the second paragraph. The company from time to time resolved not to take any public deposits at any time. Second paragraph, my lord, at page 212.
Yes.
At any time during the any years, at any time during any years under operation since incorporation. Company has stopped NBI activity during 2023-24 and is no longer interested in carrying out NBFC's business in future. Matter was discussed, resolved by board resolution dated 20th February. View of the decision, the company to approve the surrender of its registration of certificate of registration bearing numbers answered. Pursuant to his company had made several applications for surrendering certificate of registration after due compliance with all applicable laws, regulation, guidelines, various letters 18 March and 26 March. Final confirmation of the COR's cancellation from Reserve Bank of India is awaited as on date. Further, we would like to draw your attention that we were informed with the email dated 18 February and letter dated 13 May regarding non-fulfillment of meeting the minimum regulatory norms, that is maintaining minimum NOF of INR 5 crores. 18 February, my lord, recalls the first letter, my lord, which I showed, of 5 crores by 30th March, in reference to which we had resubmitted our application requesting voluntary surrender of certificate of registration, terms of 45 IA 6 of Reserve Bank, copies of correspondence. Then, my lord, last, we draw your attention to the fact that we had applied for cancellation of a license and voluntary surrender of the certificate of registration before 31st March, with the application dated 18 March, 26 March and 6 June. However, we had been informed by your office with the email dated 4th July 2025. And then, my lord, original mail dated 23rd April 2025 was not received by us and was not delivered to our inbox. That our application for voluntary surrender of CR has been rejected since the company is maintaining PBC, principal business criteria, as financial asset and income ratios were exceeding the threshold percentages as prescribed. Quite naturally, because I'm still an NBFC. Unless you cancel, I can't go back. In this regard, we would like to state that the company does not intend to carry on NBFC business and pass necessary resolution to the effect. Therefore, the company's primary activity no longer be financial in nature. Therefore, the company is not required to be registered and regulated as an NBFC under regulatory framework established by RBI. Further, financial assets held by the company as on date are by of surplus funds parked in market-linked investments such as mutual funds. These available funds would be considered for deployment in alternate business activities, non-financial in nature, to be undertaken by the entity. Once we receive the confirmation for cancellation of NBFC license, along with surrender of CR from your office, we would also like to bring to your notice that we had received an email of 18 February for achieving the maintenance of net owned fund, followed by a letter of 30th May regarding the same subject. We have informed your office via a letter dated 6 June that the company has applied for cancellation of NBFC and CR, sought several appointments with the office to discuss the matter in person. Yet present the financial figures, if your good self, not yet received any. Yet we are all grateful, kindly approve application for surrender of the CR. So this is, my lord, where we stand, my lord, on facts.
Yes.
My lord, there is a judgment on this, and my lord, I found it, my lord, extremely interesting. Right, my lord, I don't know, my lord, perhaps my lord has already come across this judgment. My lord,
yes.
Harinagar Sugar Mills, okay, 2025 SCC Online SC 1303. Paragraph, my lord, 10. Internal main page, my lord, at the top right left hand corner, page 18.
Yes.
This, my lord, arose out of, my lord, sugar mill wanting, my lord, to then, my lord, close, my lord, their division. And then kindly see paragraph 10. If there exists the freedom to set up and run a trade business as one sees fit necessarily, there has to be a set of rights vesting with the proprietor owner to take decisions as may be in his best interest. At the same time, it is true that the law does not permit such owner or proprietor to take any and all decisions without having considered and accounted for the impact that shall have on the employees or workers that are part of the establishment. This is evidenced by the provision enacted above providing for a detailed procedure followed when a person wishes to shut shop, but concomitant providing that if the concerned government does not take action with reasonable expediency, business owner should not be saddled with the costs and responsibility of running the business indefinitely till such time the authority arrives at a proper and just decision. The sum and substance are that Article 19(1)(g) includes the right to shut down a business, but is of course subject to reasonable restrictions. This interplay of Section 19(1)(g) and Section 25(o) of the Act. This is the engaged in the attention of a constitutional bench of this court in Excel, where when it was cast with considering the constitutionality of Section 25(o) as it then stood, subsequently amended, challenged before the court, upheld and reversed. Then, Lord, 11, just, my lord, I'll read out, my lord, from part of, my lord, Excel, yes, Excel, where the HON'BLE writing for the court made some pertinent observation which to reproduce, just, my lord, the underlined portion 20. But then, as pointed out by this court in Hathi Singh case, the right to close down a business is an integral part of the right to carry it on. It is not quite correct to say that the right to close down a business can be equated to place at par as high, the right not to start and carry on business at all. So, my lord, I am on the question, my lord, now that, my lord, I have applied, and then, my lord, in their reply affidavit, my lord, this is in the form of a report in the form of an affidavit, my lord, which was called for. My lord, will kindly take, my lord, paragraph they set out 45L, which is, my lord, from 45I, which is, my lord, the portion, my lord, under NBFC. Page 4, my lord, will show the act itself. Then, my lord, at page 5, also, my lord, can look at, my lord, 45A, which has been set out. These are, my lord, the requirements. 45 1, this is, my lord, when they have to grant a
That is a grant of certificate.
grant of certificate. Then, my lord, paragraph 6, my lord, they talk about
Just same certificate.
yes. Then, my lord, paragraph 8 at the bottom, my lord, will find this is, my lord, where may I just read, my lord, paragraph 8, 9, and 10, which is it is further submitted as defined in section 45 IA read with section 45 IC in sunset. Any company which carries on business of a non-banking financial company as a principal business treated as NBFC. So this is not very important. For this purpose, the term principal business described defined as RBI and such, wherein mentioned that if a company's financial assets to total assets, net of intangibles and financial income to total income are more than 50%, that is, if it is meeting the twin condition of principal business criteria, it would be identified as an NBFC. Accordingly, a company would be required to hold a COR from the Reserve Bank of India so long as it is meeting the twin condition of the PVC. Copy of the press release. Then 9. It is also submitted that RBI may cancel COR of an NBFC on account of voluntary surrender in terms of section 45 IA 6(1) of the RBI Act if the NBFC ceases to carry on the business of a non-banking financial institution. That is, it is not meeting the twin condition of PBC. Therefore, it is submitted as long as the NBFC meets the PBC. Voluntary cancellation of COR cannot be permitted. For voluntary cancellation of COR before submitting application should ensure not meeting the PBC. Lord, where is it that they said this?
The principal business criteria. So therefore, it is submitted that the long as an NBFC meet the PBC, voluntary cancellation cannot be permitted.
So, Lord, they are saying, Lord, if Lord comes back to paragraph 8 at the last 3 lines, it is mentioned that if a company's financial assets to total assets
are more than 50%
and financial income to total more than 50%, then Lord, it becomes PBC. Which means, Lord, if I satisfy PBC, I have to go and register myself as an NBFC.
If you're not required, if you're not interested,
then because I was already registered as NBFC. Now, if I'm not interested, then you have to come and tell me. You have to give me the permission to say, you please dispose of. You please decrease your PBC before I can. Because if I dispose of my PBC, you would say you're violated.
Correct. Then you will be in trouble.
Yes.
Or you give the timeline.
Correct. That's exactly.
You give the timeline for reduce your PBC.
Yes. Yes.
Once you reduce the PBC, then
I will cancel your registration.
Automatically, it will be cancelled.
Because I can't on my own reduce my PBC when I'm still registered as an NBFC.
Once you request for reduction of the PBC, then you will be in trouble.
Yes. Once I reduce the PBC, you will say that you are an NBFC registered, you are violation.
Correct. So you violated the conditions.
So this is Malad, paragraph 9, Malad, this is exactly what they say in paragraph 10, Malad, they give the figures, which is correct. I'm not denying it. That's why I said, please cancel my NBFC registration.
No, only here the point is whether the PBC is required to be reduced prior to or whether
correct.
Or you will allow me to reduce the PBC.
Whether you, if that is what you wanted, you should have, in reply to Malad, what they said, they should have said, I'm giving you 1 week, 2 weeks, 3 weeks, 4 weeks.
That's why.
Please reduce your PBC, then I will cancel. Or it is a conditional cancellation on the basis that you reduce your PBC.
Conditional, it cannot be.
If you're not conditional, then Malad to say that you please reduce your, then because then I would have been doing it under Malad his guidance.
Correct.
Because if I reduce my PBC on my own, tomorrow they will come and say, sorry, you've reduced your PBC, you're still an NBFC.
So that is the only point.
That's the only point. That's the only
point. How the PVC will be reduced?
Milord, don't quote me on this, but Milord, what my learned senior friend said, Milord, is the exact method by which the PBC criteria can be bypassed. For example, Milord, the definition in the RBI Act says a financial institution is an institution which invests in stocks, bonds, and mutual funds. Now, Milord, thinking out aloud at this point, if, Milord, the funds which are owned by the NBFC are not invested in stocks, bonds, and are rather kept in an FD, then the interest generated, that income will not be a part of financial income. Therefore, they will not meet the 50% criteria in terms of the press release. And hence, my lord, the CA certificate that will be annexed at the time of filing of that application will clearly show that the percentage of financial assets to total assets is less than 50%. The percentage of financial assets to total assets is less than 50%. Both the principal business criteria are not met. Hence, an application will be accepted. Well, that would have been the normal course. My lord, I shall take your lordship to the entire petition, to the press release. And my lord, on maintainability, they have an alternative remedy of filing an appeal. 45A7 gives them the opportunity of filing an appeal.
No, that's correct. But if your this thing is itself is strong, so what can be done?
Well, they do not. They are continuously meeting the principal business criteria. Kindly see 126. Well, it is their CA's own report.
Correct. They are maintaining.
Yes.
So how they can reduce?
Because I'm already an NBFC, but if I may interrupt.
He is already an NBFC. Correct. So if he is an NBFC, the principal business criteria has to be maintained.
Yes.
Correct. If that has not been maintained and it has been reduced, so it will be a violation of the terms and conditions.
May I say two things? There is a difference between net owned funds and principal business criteria. Net owned funds is the total funds which an NBFC, which is an investment company which the petitioner is, has to maintain.
Correct.
The PBC is a different criteria. The PBC is principal business criteria. The kind of investments you make and the kind of returns it generates, that determines the PBC. Net owned funds is different.
Correct.
If they do not maintain the net owned funds, then they would invite violations of the RBI Act and perhaps.
So you shouldn't, if the principal business criteria is reduced, there will be no, there is no, what we can say, violation of any terms.
Kindly provide for that, Malad. We will.
In terms of the PBC, Malad, I am not saying that. Kindly see the press release. Kindly see the press release in my report.
Net owned fund is, they have asked for a criteria to increase your net owned fund. That is different.
Here you're not on the net owned funds.
We are only on
the
PBC.
So PBC, how the PBC will be reduced? You have to show you are the expert body.
Yes.
You are the father of the all these things. So you have to show the way.
Lord, on that I have to take instruction.
So I am already an NBFC.
That's what I'm telling.
Exactly.
He's NBFC. He has to maintain all these things. So if you're telling that the PBC is to be reduced, so how it is to be reduced? If you say if the PBC is reduced, he will not be in trouble with regard to the NBFC license, then he will reduce.
Yes. Lord, kindly see the press release for a moment. On that, my lord, I shall take instructions and come back. Lord, kindly see the press release. Lord, that is page 9 of the report that has been filed by RBI.
Yes.
This is 8th April 1999.
Correct.
The Reserve Bank of India today announced that in order to identify a particular company as an NBFC, it will consider both the assets and the income pattern as evidence from the latest audited balance sheet of the company to decide its principal business.
Correct.
The company will be treated. Now, kindly note the word.
Correct. Company will be treated as an NBFC
if it's one, financial assets are more than 50% of its total assets.
Correct.
And 2, income from financial assets should be more than 50% of gross income.
Correct.
Both these states are required to be satisfied as the determining factor for principal business of a company.
Correct.
So, my lord, if both these criteria are satisfied, you are an NBFC, go take registration.
It is there. That first criteria is fulfilled because he is the NBFC. There is no dispute with regard to the first paragraph. So now what would be the criteria if you don't want to continue with the NBFC?
That's right. That's the point.
So, my lord, essentially,
what is the way
ahead?
What is the with regard to this? There is no difficult because he is the NBFC, and it is not your also case that they have not complied with other maintaining the 50%.
Yes.
That is not case. So now your case is that the PBFC, the what it is called?
PBC.
PBC is to be reduced from the 50%. So how it is to be reduced? Who will allow?
And my lord, their internal communication not also given to us.
So if the petitioner will reduce the suo moto PBFC for not going to the NBFC, whether you will not take any action
Yes.
because of the violation of the terms and conditions.
Because I'm still registered.
Because registration is not yet cancelled, so he has to go by the registration.
In that case, perhaps what would happen is that since in this year, the petitioner no longer carries on that business of owning stocks, mutual funds, then they will come out of the definition of financial institution since they are not meeting the PBC.
No. If it not, if we not continue, and is BBC reduced, so that is a violation of the.
Yes.
Because you are not taking care of your registration.
Allow me to take instructions on the way ahead and come.
And now you are saying,
if you say there will be no problem if it is been reduced automatically, if the petition will not take it, I will record your submission, then it will.
and now they're saying, well, the net owned fund has also now gone up. You're saying March 31 net owned fund also now make it to net 10 crores. So it's
And
a
my lord,
cycle.
this is without prejudice to my principal argument, my lord, that this writ petition is not maintainable.
I will take care of it.
45 IA7.
Okay.
They have an alternative remedy of preferring an appeal to the central government. They have not done.
Okay. That I will
No
take care
hearing,
of.
nothing to us.
That you. Yeah. Learned counsel for the petitioner. Parties have argued the matter at length. Learned counsel for the petitioner respondents prays for time to take instruction. According cases adjourned. Let the how much?
You know, will you be allowed to pleasure to exactly record, my lord, what shall I come back on?
Okay. Learned counsel for the petitioner has concluded his argument. Full stop. Learned counsel for the respondent has relied upon the press release dated 8th April 1999. Full stop. This court find that admittedly the petitioner is the NBFC. Full stop. Now the respondent's authority and now the petitioner intend that now the petitioner is not intending to continue as NBFC and requested the RBI for cancellation of the registration, surrendering of the registration certificate. Full stop. In reply to the request made by the petitioner, RBI has requested the petitioner. Where is that?
Yes, my lord.
RBI has requested the petitioner.
My lord, page 160. Under the PBC criteria.
Yes. No.
Volume
160.
160.
Requested the petitioner to voluntary surrender of COR is rejected since the company maintaining the PBC as on December 31st, 2024. Full stop. Counsel for the petitioner submit that if the petitioners of his own reduce the PBC, it will be the violation of the terms and conditions of the license issued to the petitioner. According to the petitioner, learned counsel for the respondent is directed to take instruction how the quantum of the PBC can be reduced so that the request made by the petitioner for surrendering of the certificate can be allowed. Let the instruction be let the instruction be furnished on
2 weeks.
2 weeks.
The central office, they will take instructions.
On mail within 10 days. Within 10 days, list the matter on 23rd. No, 23rd.
27th then, my lord.
27th.
Because 23rd is a holiday.
27th. January.
At 3 p.m. my lord. 3 p.m.
3 p.m. I don't think. 27 में होगा. 3 p.m. है. ऊपर कर. To under the matter to be mentioned.
Will you be allowed to pleasure to record the point of maintainability?
The respondent has raised the point of maintainability. The same is kept open.
Affidavit, my lord, it's not there, my lord. In the affidavit, it's not there. No question of maintainability has been taken, my lord. In the, my lord, this is the exception, my lord, to the report.
Exception filed by the petitioner is kept with the अभी ना कल के ऐसा appellate side morning.
I'm grateful.